Several memos.
Not that urgent.
Originally, there is the 75 years old, my
All
lord.
right, that we will see. I have seen all the mentioning slips personally, except those which were filed on last Friday. All right.
My lord, last Friday, I have also filed a memo in
I
online, my lord.
take care of the cases of old people also, the senior citizens.
Pensioner.
I'll see.
So I have filed.
I'll see.
I may be pardoned, my lord.
Much better for assignment.
Why?
For assignment.
Assignment. Why?
Lordship, we had filed a writ petition for taking a rehearing of a writ petition number 2618 of
So
2000.
subject is not assigned.
It was assigned, Your Lordship, before Honorable Justice BP Satpathy. He has recused the
You
matter.
don't have to. Order must have been passed by now. All right. And if it has not been passed, it will be done. You are not required to make a mention. One. And this is how you will test the efficiency of the Chief Justice also, whether something has been done or not. All right. And if something has not been done, it will be done. Don't make a mention.
My lord, I may be pardoned, my lord. I humbly crave my lord's kind leave for making a mention in respect of item 47. My lords have been pleased to direct the office for listing of the matter, keeping in view urgency of the matter. May
Is that
for
PIL?
launch.
Is that a PIL again?
No, my lord. It is a read appeal.
All right, we will see.
May it please, Your Lordship. Pardon me, Your Lordship. Pardon me, Your Lordship. Item number 42 and 43 to Your Lordship's board, my lord. My only prayer is, my lord, if it does not reach, can it be taken up before rising, my lord? It's a case, my lord, where similar matters have already been disposed of by a coordinate bench. My lord, because this was pending, they have already initiated certificate case. That is my predicament, my lord. If Your Lordship wishes, my lord,
Make a mention after recess at 2 p.m.
At 2 p.m. Grateful, man. I shall do
Right.
that. Grateful, man.
We will.
Lordship, here the petitioner is emerging as a successful bidder, but yet the bond order is not being issued. This matter was being listed but has been delisted from the list as the.
Will again be listed at your instance. Give your slip.
Today's weekly list, page 5, item number 26.
Orders.
May please, the lordship. And here the appeal is under conviction under the ground of circumstantial evidences, my lord.
What is the custody?
My lord, custody since, my lord, 18/3/2013, my lord. I have filed an short date chart, which is at flag E, my lord.
When you are in custody?
My lord, since 18/3/2013, my lord.
And what is the date of filing of your appeal?
And the date of filing of my appeal is of September.
And your antecedents?
No antecedent are there, my lord.
So, a judicial officer, lady magistrate, allegation is that out of these two appellants, lords, one had lords extramarital relationship with her lords. Alleged that due to that there was a quarrel in their families. So his younger brother lords went to the house of the judicial officer in the night, stayed there, and in the night committed her murder, lords, and left the house. Thereafter, the dead body was recovered, and lords, there are clinching evidence that the fingerprints of that lords appellant are there on this glass, drink water glasses, almirah and everything. These are the.
We can expedite hearing,
Yes,
final
Lord,
hearing, since he has remained in custody for
immediately, like
11 years. Then
immediately after the vacations, we also made ticket for hearing.
the present I number 12, this application has been filed for the appellant of title of sentence. His release on bail during the pendency of this appeal. The section 389 bracket and 1 of the CRPC. The petitioner, the applicant stands convicted of the offense permissible under section 302 of the IPC and has remained in custody for more than 11 years. Prosecution counsel appearing on behalf of the appellant has submitted that the appellant's conviction is based on circumstantial evidence. And since he has remained in custody for more than 11 years, and there is no likelihood of this appeal being taken up for final hearing in near future, he is entitled to suspension of sentence and he is released on bail. So, next. Mr. L. Samantrel and AGA appearing on behalf of the state has argued that it's a case of gruesome murder of a judicial officer. By
not so, both, one is not.
No, ma'am.
By not so,
how
appellant number one,
how is appellant number one related to her?
they are both are brothers, not.
Both brothers, but who are they?
Not so,
They are, my lord, appellant number 2 is one of the senior clerk of Nayagarh district judge. He was also on the same day, he was in the court, my lord.
Appellant number 1 is related to
Appellant number 2 brother, my
his
lord.
brother, my lord, and appellant number,
I think 120B is also there, 120B 201.
Yeah. 201.
he and submitted that instead of allowing the apparent privilege of suspension of sentence and grant of bail, this court may consider expeditious conclusion of the appeal itself, conclusion of the hearing of appeal itself, also for the reason that the appellant has remained in custody for 11 years and there are chances for the probability and there is more probability of the finding of conviction being affirmed. So stop. Next. Be that as it may, considering the rival submissions advanced on behalf of the parties as noted above, list this appeal for final hearing October free. For final hearing, we date hai October.
October 2nd week or November 1st week?
21st of October.
Because of the reopening day.
21st. 25th of October. The Friday.
25th is a Friday.
25th of October to be listed before a bench as may be directed by the Chief Justice. All right.
Obliged,
So come prepared on 24th.
my lord.
We don't know. This bench may be there for you on 24th. No, on 25th. On 25th. You can do it.
When
Obliged.
87, my lord. There is a delay of 108 days.
Yes.
Somebody has appeared.
Nobody has,
Somebody has appeared.
notice has to go. Nobody has entered appearance.
Notice had been issued, Mr. Das. Somebody
Yes,
has
ma'am.
appeared.
I'm sorry, my lord. Notice issued on 31/1/2024.
Somebody appears, the name
Mr.
appears.
Lakshman Pradhan. DP Das.
None appears for the respondent when the matter is called in order to give another chance to the learned counsel. List the case next week. Yeah, what is the date? 30th, whatever you say, check the date and 7th. Seven.
28,
Your Lordship.
36 days delay.
My lord.
There is a council. Yes.
So it's for the other side.
Sorry, my lord.
Similar. You accept notice?
36 days delay. We are condoning. No private party.
No private party.
GP is
Only
party,
sub-
Gram
what is
Panchayat.
a
Gram Panchayat.
Gram Panchayat?
Issue notice, this I has been filed for condoning the delay of 36 days. Filing the recovery. Issue notice to the respondent of the opposite parties. Notice on behalf of respondent 1 2 years. Private party. Is accepted by Mr. M.K. Pundia and an additional government advocate. Requisites for issue of notice to respondent number 4.
My lord,
Right?
7 and 8, my lord, is from the.
7 and 8. Respondent 7 and 8 shall be filed by Friday. Notice shall be issued, making it returnable within 4 weeks. Just after 6 weeks. 6 weeks will get added.
29,
29, my lords, are me permitted to appear through VC, my lords. It's a delay of 7 days.
Private party, right? The same
My lords, it's the insurance, reputation of insurance claim, the private companies and ombudsman.
So, ombudsman or notice?
Ombudsman, my lord, may not be necessary, but respond number 2 and 3, notice may be.
Yes.
Both.
Ombudsman,
No.
2 and 3. Acha. Both recently and I. Issue notice to the respondents of the opposite parties 2 to 3, the matter of admission of appeal as well as the IA for condemnation of delays. Full stop requisites shall be filed within, requisites shall be filed by Friday. Full stop notice shall be issued, making it returnable within 4 weeks. This time. This time, no, 6 weeks. This when? Dates.
18 million.
18. Okay.
30,
Here the petitioner has challenged the order of the honorable single judge under Annex 7.
Matter
Asking-
remanded, why you agree? Matter has been remanded.
Yes, it's been, I agree, I'm satisfied. Lordship, kindly see. Lordship, I'm just pressing 1 to 2 lines. That's that. By referring,
Just a minute. So it has come for orders for condonation of delay. What is the delay? What is the delay? Item number 50.
No private parties.
no private, government.
And upstairs.
Delay 41 days in filing the writ appeal. For the reasons stated in the IA, we are satisfied that this is a big case for condoning the delay. Full stop. Delay is condoned and IA is allowed. Full stop. IA is allowed and accordingly disposed of.
Yes.
This one another day. List, this for admission, fresh admission on 7/10/2024.
710.
7/10 next week. We condone the delay.
All.
31,
31, my lord, there are 200 days delay, my lord.
Notice. Certified copy dispatcher. Any private party, only
Well,
sole
Respondent.
respondent.
Limitation.
So 4 weeks, 6 weeks. 32.
32.
32. I have filed a miscase for exemption of filing certified copy passed by the Honorable Single Judge. Since I have filed the earlier writ appeal challenging the order of Honorable Single Judge, wherein I have filed the certified copy. That writ appeal was disposed of granting liberty to file another writ appeal enclosing all the annexures. Accordingly, I have closed writ appeal.
In earlier writ appeal, also file a limitation petition for delay and withdraw the case
Then
again.
the delay was condoned.
My lord, then again file a case, then delay, my lord. My lord, case is my honorable single judge pass
It's
order.
a case of condonation of delay only.
Yes, my lord.
Delay of 588 days. On the ground that he had earlier preferred a writ appeal,
Yes.
which was in which condonation of delay, the delay was condoned. And thereafter he has filed present appeal because he was given liberty. So at least he is in a position to explain the delay. If you want to file an objection, file an objection.
Yes, I have filed objection, my lord.
Otherwise we can condone the delay. We can hear your writ appeal on merits. His writ appeal on merit.
Of convocation any day since he has entered appearance, your lordship fixed a date on that date it can be disposed upon.
You want to file a objection? Or
Yes, I have filed objection, my lord.
You have filed?
Yes, no, I have filed. Today I have appeared. Kindly, I have not received any copy, my lord.
You have
Limitation-
filed or will file?
Will file, my lord.
Yes.
Always.
Mr. Tapan Kumar Pal and a counsel who has appeared on behalf of the respondent, accept notice, accepts notice, not accept, has appeared on behalf of the respondent on advance by waiving notice, full stop. Copy of the IA be served on him by
In course of the day.
in course of the day. 2 weeks time is granted to him to file objection if any. This is the case on 22/10/2024.
Yes. Obliged.
33.
Along with, give the earlier writ appeal number, please.
892.
Along with the records of
892 of 2023.
along with the records of WA 892 of 2023.
May I please, your lordship? My lord, 9 days delay in filing this writ appeal. Item 33.
Who is for the other side?
Okay.
Condone.
9 days, 9 days.
Next.
Huh? Next. 7.
34.
Yes.
My lord, 200 days delay.
I am for the respondent number 1, private respondent. I have filed my power since 23rd of this month. My name is not in the board. I may serve the copy of the WA and then after.
I'll serve in course of the day.
What is your name, please?
Madam.
Upon Nata.
Prabhas Chandra Mahapatra. My name is not there.
Yes. So sole respondent.
Yes.
First respondent number 1.
Mr. Prabhas Chandra Mahapatra, learned counsel submits that he has entered appearance on behalf of the respondent when? 1 year.
Respondent number 1.
When?
On 23rd of this month.
On 23/9/2024. Copy of the IA for condemnation of delay. Mr. M.K. Khuntia, Learned Additional Government Advocate, undertakes to serve a copy of the IA for condemnation of delay on Mr. Mahapatra in course of the day. How many days do you want for
It may be
filing?
listed any day.
Okay. List the case on 7/10/2024.
I'll serve only IA copy or read.
Only.
Both
Yes,
or 267 days, only
Roughly
the
on the.
yes, ma'am.
IA.
35.
The name of Mr. Mahapatra will reflect it in the
Days delay
constitution
by
next date.
Other side is private opposite party OP number 1 and
How much?
6 days. My lord.
Yes. Control list for fresh admission on 7/10/2024.
36.
The delay of 6 days. As in the period of delay, the reasons stated in the IA. In the interest of justice, we control.
May I please, my lord. My lords, WBC number 1963639 of 2008 was filed. Thereafter, no.
This is for
appearance-
restoration.
Yes, my lord.
This is for restoration.
Yes, my lord. Thereafter, no counsel was appeared for the hearing of the case. The dismiss and the retrieve time of 30 days was given. But due to the delay, I filed the.
No, when was the writ petition dismissed?
2018, my lord.
After 6 years you have filed.
Yes, my lord.
Very difficult.
There is no appearance of the counsel. Thereafter, the.
No, but 6 years is a long time. Sorry.
And the impugn order says that even today the counsel for the petitioner is not present.
Yes, my lord. That was on back in 2018.
So we have understood, but is there any reason why you did not appear and did not know?
My lord, the person who approached the council was not following up, and thereafter the corona time period was also.
Okay, if we deduct the period which the Honorable Supreme Court has said for corona that will not be counted, then what is the period of delay? And who are the opposite parties? That is important.
There is no private opposite party. My lord, Union of India is there. General Chief Postmaster
There is none for the other side.
No, my lord.
So it is the central government,
Yes, my lord.
it's no private.
Have you served a copy?
Yes, my lord. I have served. Also filed the receipt on the counter.
Nobody has appeared.
No, my lord.
Mr. Padhi, the other side, we must have served long ago when.
And what is the matter about?
Matter is about.
Gotchait is there now. Mr. Gotchait there and VC.
Mr. Gochayat, item 36.
My lord.
You
My
there?
lord, in this case, my lord, copy has not been served upon us.
Serve a
No
copy.
other copy.
Yes, well,
What is your name, please?
Satyajit Das.
Mr. Satyajit Das, Learned Counsel, undertakes to serve a copy of the IA for condemnation of delay on the Deputy Solicitor General.
Thank you. Grateful.
By tomorrow, list the case on 7/10/2024.
37.
Yes.
We do not find in the merit in the writ application, which is accordingly dismissed. No order as to cause. You'll get the order by tomorrow. Some corrections are there. You'll get it.
38.
The two amendment application is filed. The one is the proceeding which is behind back of the petitioner to blacklist and impose 20% penalty. And subsequent amendment will second one another when the petitioner is ready to execute the work within a period of 6 months. This Honorable Court specific 6th May 2024 pleased to direct to take instruction. Now they invited a fresh tender. So this want to be incorporated in the writ application.
Do you want?
This two IA that to be incorporated in the present application by of amendment. One is they have decided behind MAC to blacklist.
This application has become infructuous, your IA.
No, the your lordship has a pendency of the writ petition. They have subsequently invited. I could not execute it in time. My extension, they not consider, they behind back a proceeding was initiated, and this honorable court directed
Proceeding for what?
pardon lordship, proceeding they have the for 20% penalty as well as, my lord, to blacklist me, my lord.
Blacklisting? And what was your original prayer in the writ petition?
To allow 6 months time to complete the balance.
Oh, no, those are two different.
No, what
That is different cause of action.
No, my lord, your lordship, pursuant to the order which was refused based on the order of this proceeding, my lord.
All right, but as you wish. If you want us to decide both, we will decide both.
And the regarding and the retender, I want to, my lord, I have to complete within 6 months, my lord. They now re-invited the tender for the 9 calendar months.
It is up to them.
That's why I want, my lord.
You have to complete means you are prepared to complete within 6 months.
Yes, your lords, I'm ready and willing because of to
Yes.
avoid penalty, to, my lords, the reasonableness or minimize the
We
problem.
are satisfied about your performance.
Your lords,
They are satisfied that you can't do within 6 months. That is why they prescribe 9
exactly, my
months.
lord. The order, the progress was because of, my lord, what I'm saying, your lordship, kindly, my lord. Oh, my lord. But if the termination is the proceeding which upheld, my lord, then I will liable for 20% penalty and other, which is severe impact, my lord. Even I could not participate in the tender, my lord. So, my lord,
So
what
we'll
I'm
consider your.
amendment, your lords.
No order is required to be passed for the presence of these applications. Okay. Business matter for admission. Admission we will hear.
One more, your lordship, there is a order, your lordship has, I have filed a IA for stay of that proceeding.
No. IA concept.
Is it? And
IA number.
yes.
No, dismiss the. As we are inclined to take up the.
What
We will take up for admission.
your lordship, similar one more, my lord. 6th May, your lordship has specifically directed to take instruction whether, my lord, petitioner undertake before this honorable court, he will complete 6 months to avoid penalty. My lord.
See, your matter has come for order.
Yes.
You are arguing on merit. You want to argue on merits?
No, my lord, I don't. I think no coercive action, at least, my lord, pendency it will be.
No question of no coercive action.
The blacklist, my lord.
Therefore, we are ready to hear you. Give us a date, we will hear you.
Is your lordship, please.
In fact, he had filed an application, an affidavit saying the 6 month time increment granted. We have issued a fresh notification, so automatically we don't want to extend the time.
So
Now the proceeding.
All right, we will hear you tomorrow.
Is your lordship, please.
You got your instructions?
Discuss matter or admission within first 5 cases.
Counter have you filed?
No counter.
All right, tomorrow.
39.
Then you want to withdraw the. Withdraw. IA for withdrawal.
You're Mr. Das?
I have learned one sentence today. Apan karo nata kon. Yes, next. One.
Item number 1.
Just it.
I have a preliminary objection regarding maintainability of the writ petition before this honorable court.
Yes.
So lordship would permit, I may address on that first.
Yes. Because he is raising preliminary objection, he has a right to address.
But it's only counter affidavit has been filed by him. There is no specific stand that there is a preliminary objection.
Maintainability can be raised.
Well, let him argue, no problem.
Actually,
please check. Can you please spare some chair for the learned counsel to access time? Yes.
the petitioner is basically a consultancy service. There was an agreement.
No. How is the writ petition not maintained?
Yes, Lord, the agreement which was signed between the parties. Lord, I represent the National Highway Authority of India. He was, Lord, engaged to render consultancy services. Lord, it's a consultant. This is the work is with regard to the execution, the 4-laning of an existing 2-lane road. Similar, because the petitioner recommended around 26 illegally, 26 crores for being paid to the contractor, even before the completion of the work, which was subsequently audited and found to be correct to the tune of 35 crores illegal payment. So the agreement was terminated, which was executed in Delhi. So there is an integrity pact, which is a part of the contract agreement. There, the stipulation is that the jurisdiction would be in Delhi.
Where is that?
So, I'm just page 44. 219. Page 219. That is my counter affidavit. Internal page is 32 and running page is 219. This is a part of the contract because that was executed prior to the execution of the contract for rendering this service.
Page
219.
Annexure C/1.
Annexure C/1. Let's see if it is right. This pact is signed by both the.
Page 44 of what?
Page 32 of the counter and running page is 219 of the 219 of the brief.
Yes.
Other provisions, Article 10.
Yes.
This pact is subject to Indian law. Place of performance and jurisdiction is the registered office of the principal, that is New Delhi. NHI headquarter is in New Delhi. This integrity pact has been executed in New Delhi. That is between the petitioner and the Gentisa Resources Euro Studios SL Limited. He is the contractor, consultant, I mean. That is the infrastructure so and so, and between the National Highway Authority of India. If you lordship would turn to the agreement, this integrity pact forms a part of that contract. That is at page 44. Page 44,
Page 44 of?
Page 44 of the writ petition.
44 of the writ petition is something else.
Page 44.
Just a minute.
This is the agreement.
Please give me a minute.
Annexure 4, which will also put find from page 44, Annexure 4, Roman 4, Annexure 4. Integrity pact, that is a part of the contract that runs from page 637 to 640, which is the entire contract awarded in favor of the
632 to
page 637 to 640. There the document which I just pointed out from page 219 of the Annexure C/1.
This is part of the original contract.
That is a part of the original contract. There are 2 orders following this malfeasance defalcation to the tune of around 35 crores, which was illegally paid by the NHI. So the contract was terminated.
No, we are not into that.
Yes.
Whatever
So
you
this
might
the
have.
yes, no, my lord, he has invoked the jurisdiction of the Honorable Delhi High Court. There are two orders. One is a termination of the contract. The other is the debarment for 2 years to participate in the bid process of the NHI because of this conduct. So he has challenged the termination order before the Delhi High Court. And Honorable Delhi High Court has appointed Justice Nandrajo, the retired Honorable Chief Justice of Bombay High Court, as the arbitrator, Milan, to go into the termination. The next day or 2 days thereafter, he comes before this Honorable Court to challenge the order of debarment which arises out of the same contract. Similarly, your Lordship knows in Rashtriya Ispat case, the Honorable Apex Court has held that both these things can be gone into by the Honorable Arbitrator. So, my lord, that's only one paragraph would suffice. So, the entire cause of action, my lord, the award of the contract, the execution of the agreement, the termination, the debarment, everything has been issued by the head office of NHI located in Delhi. 2 orders, impugned orders, my lord, have arisen out of the same contract. One order, he chooses the forum of Delhi High Court, rightly. The second one, my lord, the debarment part, he comes before your lordship and says that it is bad in law. So my humble submission that if at all the petitioner has a case, whatever may be he may approach the Honorable Delhi High Court because of the jurisdictional issue. Number 2, my lord, the Honorable High Court has already, Delhi High Court, appointed an arbitrator to go into any dispute which arises out of the contract in terms of the...
No, but arbitrator cannot examine the...
That is exactly what has been... He may...
No,
he
cannot
may,
examine the blacklisting.
Debarment. My lord, but anyhow, that's a question, but one Supreme Court judgment is there.
You may be correct in your submission that because of that, and that is, of course, subject to what he submits, the contract is one part, and you taking a decision to debar him. These are two different things. All right. So, is it your submission that the arbitrator, the arbitration tribunal can go into the question of debarment also?
I'm just passing on one judgment of the Honorable Apex Court, Justice Sinha judgment, is subject to your lordships. This is not the issue. Issue is, if at all he may have a grievance, but that can be gone into this judgment may be looked at. Just one. Here the question was same, Miller. Termination, and he says it is blacklisting. Debarment is blacklisting. Let us assume.
All right.
So, Miller, para 43, your lordship may state the facts, Miller. So, a same fact, Miller. The same was the almost identical. Para 43 at page, your lordship would find at page 290 of the judgment.
Yes.
The submission of the Learned Counsel for the respondents that the 2 different causes of action having been raised, namely illegal termination of contract and blacklisting of the firm, the same situation here, Miller. Miller, page 290. Para 43.
Yes.
Miller, may I read again? The submission of the Learned Counsel for the respondents.
Just a minute. Yes.
The submission of the Learned Counsel for the respondents that the 2 different causes of action having been raised, namely illegal termination of contract and blacklisting of the firm, Section 8 of the 96 Act was not attracted, is devoid of merit, inasmuch as, according to the respondents themselves, both the causes of action arose out of the terms of the contract. What was necessary was to consider the substance of the dispute. Once it is found that the dispute between the parties arose out of the contract, Section 8 of the 96 Act would be attracted. That's the same proposition. Similar, that is the secondary issue maybe, but whether he would choose the forum, whether he has to challenge it in a extraordinary jurisdiction of the Honorable Court to ascertain the correctness of the debarment order, or the parties may be relegated to the arbitral tribunal, which has already been appointed by the Honorable Delhi High Court on his request.
You're right,
So
because in this case, section 8
it
interpretation.
was the
applicable
yes,
to be considered.
interim yes. So is lots of disputed questions of fact are also involved, Milord. It's a very, Milord, this finding of the audit, etc. High Court arbitral appointment, you will see, I would copy it. This was it, I would copy it. Justice Nandraju, the honorable, that judgment is there last time I had passed on at his instance. The next day he comes before here. This I have given earlier, but I am passing on again. So the termination of the agreement was challenged before the Honorable Delhi High Court. And Justice Pradeep Nandraju, the retired Honorable Chief Justice of Bombay High Court, his lordship has been appointed as the arbitrator. Either, Milord, the issue can be referred to the arbitral tribunal, as has been held in Rashtriya Ispat, or, Milord, he may be given liberty to approach the Honorable Delhi High Court, which he has rightly done in terms of the contract. So instead of, Milord, wastage of your lordship's precious time, so this is what, Milord, I precisely wanted to say.
You have not wasted, but he may.
No, Milord, that's correct. This is my humble submission.
Yes, he appears to be correct. Though prima facie.
But you may see the agreement at page 54. At page 54, ballot.
Yes.
Clause 2.5. Entire agreement. This contract contains all covenants, stipulations, and provisions agreed by the parties. No agent or representative of either party has authority to make, and the party shall not be bound by or be liable for any statement, representations, promise, or agreement not set forth herein. So this agreement is similar sacrosanct.
No, you are reading page 54.
Yes.
Of the writ petition.
Yes, sir.
Clause
2.5. Yes.
Just. So what is the date of this agreement?
Right?
What is the date of this agreement?
Well, date is the period of 11th December 2019 at page 40.
Yes, 11th of?
11th of December 2019.
Yes.
Then, my lord, Lordship may kindly come to page 56.
No, whether this agreement has
Yes.
any arbitration clause.
It has. But agreement, the arbitration is not with regard to, my lord, the blacklisting, it's with regard to termination. That is important. Let me straightway take your Lordship, my lord.
So is this your case that except for termination,
Yes,
there is no provision for arbitration?
for blacklisting.
No.
Lordship, just
There may be a clause like any dispute.
yes,
There may be a clause according to you that the arbitration is confined to termination.
yes,
And according to you, therefore, because that is confined to termination, therefore no other dispute can be gone into by the arbitrator.
Well, let me take your lordship straightway, my lord.
Language.
Straightway, my lord, to page 59.
Yes.
Clause 2.9.6. Disputes about events of termination. If either party disputes whether an event specified in paragraphs A to E of the clause of general condition 2.9.1 or in clause 2.9.2 thereof has occurred, such party may, within 45 days after receipt of the notice of termination from the other party, refer the matter to arbitration pursuant to clause GC, general conditions 8 hereof, and the contract shall not be terminated on account of such event except in accordance with the terms of any resulting arbitration or arbitral award.
According to you, this is the only provision
For and then lordship then lordship may kindly come to my lord.
Whether there is any arbitration clause in the GCC.
Yes, that is clause
8.2.1 at page 79.
Lordship kindly come to page 79. Eight point 2.1. Each dispute submitted by a party to arbitration shall be heard by a sole arbitrator. NHAI shall within 30 days propose names of 5 arbitrators from the list of arbitrators maintained by SAROD, and consultant shall within 30 days select one name from the list
So there
of
are
5.
two aspects. The 8.2 has to be read first.
Yes.
It says that if there is any dispute, it should be settled by arbitration.
It doesn't say that. It says disputes shall be settled by arbitration in accordance with the following provisions.
Yes.
And this is the provision for the purpose of arbitration.
Right.
And at page 59, my lord, disputes regarding termination.
All right. So therefore we wanted to know.
Yes.
That is this your submission that when it is referred to the disputes in 8.2, it refers only to the disputes
regarding termination. If the termination happens, then
so
what?
Whether dispute, all right, whether a dispute has any definition, whether this term dispute has been defined anywhere in the agreement.
Well, that is at page 73 again. Lordship, settlement of disputes, clause 8.
4.5, can you see that?
Yes.
Only.
And Lordship may kindly come to page 72. Everything is clarified here, my lord. The dispute has not been defined, but Lordship may kindly come to page 72.
Yes. Yes. Yes.
Not page 72, clause 7.2.
Clause
7.2.
7.2 at page 72.
Yes.
Yes.
The parties recognize that it is impractical in this contract to provide for every contingency which may arise during the life of the contract. And the parties hereby agree that it is their intention that this contract shall operate fairly as between them and without detriment to the interest of either of them. And that if during the term of the contract either party believes that this contract is operating unfairly, the parties will use their best efforts to agree on such action as may be necessary to remove the cause or causes of such unfairness. But no failure to failure to agree on any action pursuant to this clause shall give rise to a dispute subject to arbitration in accordance with clause GC 8 thereof.
Yes.
And then Lordship kindly come to 8.2.
Yes.
So, my lord, if 8.1, my lord, a dispute will mean this, my lord.
Yes.
And 8.1 is the parties shall use their best effort to settle amicably all disputes arising out of or in connection with this contract or the interpretation thereof. So, first step is to see that the matter gets settled amicably. Then, my lord, 9. Now, 8.2, my lord. Any dispute between the parties are as to the matters arising pursuant to this contract, which cannot be settled amicably within 30 days after receipt of one party of the other party's request for such amicable settlement, may be submitted by either party for settlement in accordance with the provisions specified in the special conditions contract.
Oh.
Then, Lordship kindly see, my lord, clause 9, that is the only provision with regard to, my lord, blacklisting. If any case of fake, incorrect, inflated CV is found, it shall be dealt with very severely and would result in all possible penal action, including blacklisting from future projects of NHAI. This would also apply even when the consulting firm is not successful in getting the assignment. In case CV of a person is turned out to be fake, incorrect, inflated during the assignment, the consultancy firm will have to refund the salary and perks drawn during the interest, including interest of 12% per annum in respect of the person apart from other consequences. In addition to above, 10% of the salary and perks to be refunded shall be recovered from the firm as penalty. Similar, this would have explained to your lordship.
See, everything is clear now.
Yes.
8.2 says how the disputes are to be settled.
Yes.
And then fake CV has to be viewed seriously.
Yes.
It doesn't mean that you can be blacklisted on this ground alone.
Well, there is no other provision for blacklisting.
There is no provision. If you blacklisting is their discretion, they may exercise after giving you notice.
I'll explain to your lordship, my lord.
All right, we will decide this.
Yes, well, I have got lordship point query, my lord. I will answer to that by citing judgments of Supreme Court and this honorable court.
See, in most of the Supreme Court's decisions,
yes,
dealing with blacklisting.
Yes.
The provision of blacklisting was not there in the agreement. And despite that, they were blacklisted.
Well, at the latest of the
And
judgments, I'll cite you for Lordship.
Latest of the judgment, the very first judgment which deals with blacklisting, there was no provision for blacklisting. The person was blacklisted. The only ground on which the Supreme Court interfered was that he was not giving an opportunity of.
Exactly, Malad, exactly.
Therefore, you can raise that plea before. Now he is relying on the Supreme Court's decision in case.
Malad,
of
I'll reply to the Supreme Court judgment. Now, Lordship kindly sees, Malad, what is, Malad, this notice at page 126.
Notice, these things can be the argument which you are making, you can make before the Delhi jurisdiction. Delhi has the jurisdiction. Why should we enter into such?
Malad, the Delhi High, Malad, the jurisdiction of this Honorable High Court is not, Malad, taken away.
No.
And I have approached the Delhi High Court with regard to termination. I have not, Malad, approached the.
It is better that all the disputes are.
I'll come to Lordship, Malad, so on that issue, but the judgment I'm going to cite before Lordship, Malad, that Supreme Court judgment that deals with blacklisting and termination. But there the parties confined to, Malad, the blacklisting part. And Honorable Supreme Court confined the entire finding of blacklisting. Termination was not, Malad, was taken away from the, Malad, realm of adjudication. Well, I'll cite that, Malad. But before that, Lordship may kindly see page 126.
Yes, yeah. Yes. Fine.
Well, this is the only show cause.
Yeah.
Paperless, did resist to that.
Attach it with the brief. Yes. Want us to see?
Well, page 126, Malad. This is the show cause, Malad, issued to me. I will not, Malad, trouble a Lordship with regard to other factual aspects, Malad.
No, why should we see the notice unless you satisfy us?
Yes.
That under the agreement, the Delhi courts have jurisdiction.
Malad, what I humbly submit, Malad, there is no exclusion part in the Malad agreement.
But that amounts to exclusion.
No, Lordship, no, there are a number of judgments, Malad, of the apex court and this honorable court also, where the Malad clause is the jurisdiction of other places are taken away and this jurisdiction is with regard to a particular
there are a number of decisions on the point that if the parties decide jurisdiction of a particular court or jurisdiction, then that amounts to exclusion of
with due respect, I'll cite judgment, unless the word only used. If the word only has been, if it is not used, then there is no exclusivity to the jurisdiction of a particular court.
We will decide.
Well, I'll cite that judgment, Malad. Of course, I have not got it today, Malad. So only is the key word. If there is no word only, then exclusion clause is not applicable.
After all, we have to derive intention of the parties from the language which has been used.
And Lordship, kindly see again the language, the language used, Malad. At page 220, Malad.
Yes, we will decide it.
Malad, at page 220, Malad, Article 10, it says,
yes,
this pact is subject to Indian law, place of performance and jurisdiction.
Indian law, full stop.
Yes, full stop, Malad. Yes, then place of performance and jurisdiction is the registered office of the principal at New Delhi. It doesn't say, Malad, that the jurisdiction of this honorable court is ousted. Well, had the word only been deployed here, Malad, then that presumption could be, Malad, have.
We understand yours.
Yes, and now Lordship kindly come to, Malad, that's 126, Malad. And
yes.
Lord, while I'm citing, Lord, at the document at page 126, at this point of time, Lordship may kindly come to page 206 of the counter affidavit, where they also say, National Highway Authority says, Malad, that this is the only letter issued. At page 206, my lord, internal page 18 of the counter affidavit filed by the National Highway, my lord. At page 206, my lord, internal page 18.
Yes.
It is further preeminent to mention here that from the bare perusal of the debarment order, it will be evident that the petitioner was provided with sufficient opportunity to provide explanation, clarification, document.
206.
My lord?
You are reading page 206.
Yes, my lord. My lord, internal page 18, my lord.
Internal page, that is 205.
Oh, I'm sorry, 25, my lord.
Yes.
It is further preeminent to mention here that from bare perusal of the debarment order, it will be evident that the petitioner was provided with sufficient opportunity to provide explanation, clarification, documents with respect to its fraudulent practices. However, the petitioner chooses not to comply with the same. Finding no way out and looking at the delay in the completion of the project, the opposite party was, number one, issued a show cause notice dated 18/2/2023, in which, along with the defaults which are committed by the petitioner, it was specifically directed to show cause why disciplinary action shall not be taken against the authorities engineer for the lapses made in recommending the excess payment of the contractor. Well, this is 18/2/2023 is the letter at page 126.
Sir, the submission which you are making, you could have made it before the Delhi High Court, Delhi. Why before this court? And we fail to understand why have you chosen Odisha High Court when you are already before the Delhi High Court and the matter is there.
Before the Delhi High Court, I had only raised the question of termination, my lord. I had not raised the question of the blacklisting. The blacklisting I am confining to only this honorable court, my lord. Lordship may just seize that judgment of the Supreme Court. The case of UMC Technologies, my lord.
Yes. Yes.
Lordship, when it comes to paragraph 6. By its aforesaid order, dated 9th of January 2019, the corporation concluded that the shortcomings, negligence on part of the appellant stood established beyond any reasonable doubt and proceeded to terminate its contract with the appellant and also blacklisted the appellant from participating in the future tender of the corporation for a period of 5 years. Further, the appellant's security deposit with the corporation was forfeited and the appellant was directed to execute the unexpired portion of the contract at its own cost and risk.
You are again taking us to the merits of blacklisting.
Now, Lordship, see here, paragraph 8 again.
Yes.
At the outset, it may be noted that Gaurav Banerjee, learned senior counsel for the appellant, has submitted that the appellant only seeks to contest the issue of blacklisting and not termination of the contract.
Right. So that was the contention which was accepted by the Supreme Court.
So that is the reason I'm saying, my lad, when I had been to the Delhi High Court, I had not whispered a single word regarding blacklisting, my lad.
We understand that. We understand
Yes.
that in Delhi High Court you did not raise any plea, and you are raising that plea in Odisha High Court.
Yes.
That to at least 2 hours journey from minimum 2 hour journey from Delhi to Odisha. Why should you afford that?
Lordship, I'll cite those judgments with regard only. Let's keep it to tomorrow, my lad. I'll cite this two judgments, my lad.
All right, but with the
if there is no only the word only is not used, my lad,
we will see.
Then there'll be no exclusive.
See, whatever you address, we will tomorrow. But tomorrow we'll dictate the order.
Yes, sir, yes.
Please,
correct.
Be brief and tell us what are the judgments.
Yes.
Yes, heard, Mr. Swami. Acharya Lang. Senior counsel appearing on behalf of the petitioner and it has minds met. And Mr. Acharya, and Mr. Acharya. You are senior
I'm for
counsel.
the NHI, National Highway Authority.
Number 2. Senior counsel representing the appearing for the NHA. Mr. Acharya has raised 2 preliminary objections over the maintainability of the present applications. So he has firstly submitted that in terms of the integrity, what is that?
Integrity pact.
In terms of
Integrity,
the
sir.
integrity pact.
Integrity pact.
Integrity pact between the parties, the jurisdiction for resolution of dispute lies with the courts of New Delhi. He has secondly submitted that there being an arbitration clause for resolution of disputes, including dispute relating to an order of blacklisting arising out of the contract in question, this writ petition under Article 226 should not be entertained. And so next, then senior counsel, in reply, has drawn this court's attention to various provisions of the
Chit jota koile attach kare.
various provisions of the agreement entered into between the parties to contain that only such dispute is arbitrable under the agreement which has the consequence of termination of contract. Stop. He has also argued that the clause of the integrity pact, which mentions New Delhi as the place for New Delhi having the jurisdiction for resolution of disputes, it does not contain the expression quote unquote only. And therefore, this court does not lack. This court may entertain the present writ petition. Also, he has submitted that he will bring to the this court's notice Supreme Court's decisions on this point tomorrow. So this space tomorrow as the first case.
Item number 2.
Obliged.
May I please notes?
Item number 2.
My lord, may I please?
Item number 2, who is appearing?
My lord, I am for the petitioner, my lord. I am through BC, my lord. With my lord's kind permission, I am through BC.
I have a preliminary objection to be raised about the maintainability of the writ application. So let's kindly look to the prayer. That is at page 8 and 9. It's a form of PIL. This is
yes.
In the premises, therefore, it is humbly prayed that this honorable court by guesses will please to admit the PIL, issue notice to the opposite party, and after hearing the parties, cancel the unauthorized assumption of charge, rupee number 2 as so and so. Consequent, page 9, consequent cancellation of unauthorized assumption of charge, rupee number 2 direct the OP number 4 to implement Honorable Court order dated 16/2/2023 in WPC number 4439 of 2003 expeditiously as an enforcement of statutory principles, so on. So also look to that or judgment I've given enclosed at page, that is your lordship's order, that is at page 30 of my counter. Having included that writ application as
Annexure?
that is annexure D/3. Annexure D/3 enclosed to my counter,
Yes.
page 30, that's order. That is the writ application he wants to implement. That the final order at page 30.
Yes.
At page 33, also come to page 33. That writ application stand disposed of having become infructuous. Para 4 I'm reading. Pursuant to the said interim order of this court, it has been stated by so and so, non-counsel representing Odisha State Cooperative Bank. I am also appearing for that in the light of the interim order 16/2023, the respondent 9 was removed from the office of managing director of the bank. He has submitted there is no question of respondent 9 being continued as the managing director of the Odisha State Cooperative Bank on the strength of the appointment order dated 25/1/2023, which is under challenge in the present writ application, since steps have been taken by for selection of managing director of the bank in accordance with law. In such view of the matter, the present writ application stands disposed of as having infructuous. This is my first point. The second point, you also kindly look to your lordship.
This is the same cooperative bank.
Yes, same cooperative bank. You also look to the judgment, your lordship, in one of my cases, whether a PIL is maintainable. Your lordship have said this, and I am relying upon a judgment of a division bench of your lordships and also a coordinate bench which has been reported. This is your lordship have disposed of this PIL on 19/9/2024. Sorry. I think it is the last week. This public interest litigations filed in 2011 does not comply with the mandatory requirement of the Odisha High Court public interest.
How do you say that he has personal interest?
That your lordship kindly no, what your lordship have said, that the so far the provision under the rule is concerned, that has not been complied with.
That is because
Yes, and if your lordship look to another judgment, a division bench,
what is his personal interest in this case?
so far as he is concerned,
She.
but the person who has approached your lordship, so far the personal interest is concerned, that is one part. But the other part is the rule, as your lordship, so far the Odisha High Court rule is concerned, that has been lordship look to that rule. Please give it a copy. Rule provides, yes. And that rule has been also dealt with in the division bench in that case, Asrivad Patnaik versus Union of India. Let's look to this rule.
Yes, which rule has been?
Let's look to chapter 2, rules relating to the format of the PIL petitions. Every petition filed in the court in the form of public interest litigation under Article 226 of the Constitution of India shall be in the form appended hereto and shall be heard and disposed of by a division bench presided over the Chief Justice and so on. The petition shall contain the facts of the case of chronologically ordered. If the petitioner may skip over, then 8. Before filing a PIL, the petitioner must send a representation to the authorities concerned for taking a remedial action akin to what is postulated in section 80 CPC. Detail of such representation and reply, if any, from the authority concerned, along with the copies thereof, must be filed within the petition. However, in urgent cases where making of representation or waiting for response would cause irreparable injury or damage, petition can be filed straightway by giving prior notice of filing to the authorities concerned and or their counsel, if any.
So are you managing director Odisha State Cooperative?
Sir, I am now representing the managing director, of course, pursuant to the order of your lordship. I'll show it. Pursuant to order of your lordship, in that writ application by an interim order, the registrar was directed to take over the charge of managing director from the then managing director, whose appointment was held to be illegal. Now the registrar, while continuing as such, a managing committee was constituted. Now the whole problem, so far the bank is concerned, that committee has been directed not to take it. That is the order by a single judge. This is the problem for so far as we are concerned. We all also look to that.
If I am not mistaken, the earlier application was disposed of because steps were being taken for appointment of a regular
That is
managing
right.
director.
Now the problem is
3
this.
months have elapsed since then.
Right. We also look to this. This is the problem. Because a bylaw is required to be also look to the this order was passed on 12/9/2024 at the instance of some of the members of the managing committee at paragraph 9. In view of the above, this court direct the letter dated 27th August 2024 issued by the Registered Cooperative Society Bhubaneswar OP number 2 fixing hearing of the question of supersession of the committee shall be kept in abeyance till the next date. It is further made clear that the Committee of Management of Orissa State Cooperative Bank may take decision of the day-to-day affairs of the bank, but no policy decision, more particularly with regard to appointment and posting of the managing director, shall be taken till the next day. I was told that, of course, I have not till appeared in that case, but an application has been filed for modification of this order. So far as the appointment of managing director is concerned, there is a provision of the bylaw of the society, that bank, that they can appoint by interim or by interim arrangement. That is there. You will actually look to that bylaw. But this is the hurdles. The bylaw says eight. The bylaw says
We will hear all the cases.
that's right.
In fact, if your lordship will be permitting me, my learned sir, Mr. Rautra is appearing for the managing director in charge. I'll be appearing for the committee of management. Quickly, I'll tell within 2 minutes.
No, we will all hear all the cases. There are two cases or three cases.
My lord, sir.
Now, list this matter along with WPC number 22754 of 2024 and WPC number 19207. There are three cases. 19260. This is also pending.
Lord, those are matters pertaining to 32(1) superstition of the committee.
No, whether this is pending or not.
Yes, Lord, pending.
There,
Beg pardon.
there similar order was passed. That is why this order was passed in this.
There, in fact, those orders passed by the Honorable Single Judge, if your lordship see, prior to that, there are two other judgments passed by the coordinate bench, including one Honorable Division bench, directing the Committee of Management to fill up the post of manager.
Yes.
That is not it.
Therefore, we are paying.
May be permitted to make one humble submission, my lords.
Just a minute. This matter along with WPC number 22754 of 2024, 19207. 122,754, 19207, 19260, 21136 of 21136 and 21015 of 2024 to be taken up by specially constituted division bench on Wednesday. Wednesday after reopening.
Yes, Mr. Tripathi.
My lords, in order to clarify the position.
No clarification,
No.
clarify that.
Filling of
My lord,
the
may-
has been stayed, so that matter will be heard.
My lord, may can be permitted to make one humble prayer, my lord.
Yes.
This matter may be taken up as the lead case, my lord.
Right?
Why are you a leader?
No. My lord, that is not my submission, my lord. Because my only given.
Your case can be heard by a division bench. The other cases should be heard by a single bench, but those matters are going to be taken up by a division. We will see
Then you have to come to this court. If it is a lease matter.
My
you
lords are
have to
fixing
come.
a date, madam.
Madam.
1 day after the.
After holidays, soon after the holidays, any Wednesday, because on Wednesday.
Your lordship
in
will be
the-
getting time to hear
In the
it.
second half, I sit single.
Your
and-
lordship is constituting another bench to hear this matter. Not
Yes.
your lordships.
Yes, yes.
No, my lords will be
Another
hearing.
one, I may also be there in their bench.
That is your lordship.
Bench may be different, but then because last Wednesday, I found that I did not have cases after 3:30 or something. I had to write. So that can be.
Same situation might not be there on the next Wednesday. Your lordship may be filled up.
Therefore, on any
All right,
Wednesday.
as your lordship.
That's as your
Same,
lordship.
Wednesday, same day thing will happen because all criminal matters now lordship directed me to take instruction regarding lords, whether the petitioners in
You
those
will
old
be
regions are.
getting, you will be
sleeping or
getting
not.
the list. I am getting that list
Yes,
prepared.
lords. So next,
You
so
will
Wednesday.
be getting the list, and that does not concern this bench is
Single bench.
in fact, just keep in mind that there are old criminal revision applications. In many of the cases, 13 procedure has not been followed.
Right.
All right. So whether we can take aid of that, of course, for disposal of unnecessary
Pending old
criminal revision matters.
We are 96, 97 inherited matters.
So please examine that aspect.
Yes.
Of course, I'll have to see whether 13 statement was recorded and that has been taken into account. But in such cases, where that procedure has not been followed, then that can be the sole ground for interference.
Because most of the cases, the learned trial.
Please
court has not
examine the
referred.
legal aspect.
Yes, no.
Legal aspect, there is no dispute, but still.
Yes, no. So, I will do that.
Obliged.
Item number 3.
Number 3, they file a regender reply to regender who have filed. The copy receipt. You'll serve the copy. Let's make it after 2-3 days.
There is nothing
That is an NTA matter. Yes.
My lord, NTA, my lord,
They are
admission
saying
is
that-
going on.
We will decide it.
My lord, 5 months, court of
We have understood.
my lord.
We have understood and we are prima facie of the view that in view of the stand which has been taken by the NTA, we cannot deviate from that.
My lord,
We cannot say that NTA's stand is incorrect.
my lord, I have not attempted that question.
Judgment. Heard, put up for judgment. On after vacation, the holidays, the worker will end with. All right. Judgment. Next.
21st October.
Yes. Yeah, just.
Item number 4.
May it please, Willis. Willis, I'm challenging the illegal decision of the Skill Development and Technical Education Department, Willis, in keeping the admission to my institute in the field of post-diploma in industrial safety. That admission has been kept in abeyance for the academic year 24-25. Let's vide the impugned letter at annexure at page 121 on 14/8/2020.
Initially, you were granted permission for 30 seats.
Precisely. And that has always been continued.
Then
Then for if now if your lordship will come to page 42.
Yes.
Academic audit of 12/8/21.
Yes.
That's 42 is there was an academic audit conducted by the department where Millards at page 46 your lordship will see it was recommended that considering the infrastructure, the intake capacity.
So what do you want now?
Millards, what has happened? There was 30 initially, then I went for intake of 60.
Yes.
There was a joint verification report. Joint verification report says that no, you can't increase it to 60, but 30 was always recommended. Then Millards, on 22/3/24, it was said that even keep the 30 admission in abeyance. Thereafter,
So what is that called? That proverb? What is that proverb in Odia?
Millards, नमाज बख्शवाने गए थे. But in Hindi, it's नमाज बख्शवाने गए थे, रोजे गले पड़ गए.
Yes.
Now, let's thereafter, because that abeyance of even 30 was kept in abeyance, I approached your lordships. Your lordship passed a detailed judgment, which your lordship will find at page 73. Your lordships deprecated that why the no reasons were assigned. 73 Millards will have. This is your lordship's judgment. This is the second round of litigation before you. 13/5/24. Millards will kindly see page 91, the decision of your lordships.
Yes.
Para 8. Perusal of record transpires that the Petitioner Institute has been granted affiliation with intake capacity since 2011 and was renewed each year. In the year 21/22, when academic audit was undertaken by the inspecting officials comprising so-and-so, in respect of PDIS course by a report dated 12/8/21, it was suggested as follows. The chairman of the institute is requested to take steps for installation of CC camera in the classroom and laboratories, etc. Considering the infrastructure, the intake capacity may be enhanced from 30 to 60. It was recommended to be enhanced from 30 to 60 on 12/8/21. Then Millards, however, on subsequent joint verification report of 2/8/23 submitted by the expert committee members comprising so-and-so, suggesting for intake of suggesting for 30 intake instead of 60. So there said it not 60 but 30. The notice to show cause was issued by Joint Secretary to Government of Odisha and Skill Development and Technical Education.
So where is the order now? Where is the order?
The impugned order before your lordships today?
Yes.
Millards, that's at page 121.
That order must have been passed after this order.
Yes.
Yes.
Millards will see page 121. (14/8/24). In inviting a reference to the subject cited above and letter under reference, I am to say that the government in SDTE department have been pleased to regret the proposal submitted by you for allowing Sivanand in his Institute of Industrial Safety to participate in the PDIS admission process for the current academic year 24/25 with an intake of 30 seats in accordance with the previous decision taken in the third Apex Diploma admission meeting such and such under the chairperson of the Principal Secretary to Government in SDTE department to keep the admission in abeyance with respect to Sivanand Institute of Industrial Safety Angul in PDIS course for the academic year 24/25, considering the recommendation of the Joint Inspection Committee report conducted on 9/7/24. From the photographs attached with your representation, it could not be established the institution is ready for taking admission with 30 intake capacity and run the PDIS course. Millards, this 30 was never under question. What really happened, Millards?
No. There is no question of not under question. The question, where is that report?
Yes, Millards. Millards, that
Page 15, at 1, 2, 3, 4, 2 and 3.
I'm sorry, Millards.
Page 15, which you read to us, where it is stated recommended 30.
Yes, Millards.
What do 2 and 3 mean? 2 and 3 in that page.
Page 15, Millards.
Yeah, page 15 of the what you
Counter.
Whatever you were reading, annexure C/3.
Plus, I was reading page 121
Maybe I'm on the wrong
of
page.
the writ petition. The counter has been filed,
Please repeat the page. What?
page 121 of the writ petition.
That is the impugned.
Yes, Milas.
No. Could not be established.
No, where is the report?
Yes, Milas. That report. Yes, Milas. 103. Date of inspection, Milas, 9/7/24. Recommended, nothing, not recommended. Intake, nil. During joint inspection to such and such institute, dated 9 July 2024, following observations are made. The additional construction renovation of existing building is under progress. Due to renovation work under progress, the required practical lab classrooms are not ready. The faculty salary payment through cashless mode of transaction could not be produced to the team members. Nevertheless, this is a joint inspection report which was carried out on 9/7/24. Let's two submissions, Willets, to this. One, Willets, the Honorable, your Lordships, when your Lordship passed this, there was no direction to carry out another joint inspection. That is number one. Number two,
That is
very well. I bow down. Number two, Millets, I gave them a clarification at page 104 that, Millets, what happened when this litigation was going on, I was also in the process of increasing my capacity.
maybe
And therefore, Millets, I am carrying out some renovation work.
you are interested in increasing your capacity, not in maintaining the capacity which was sanctioned.
No.
So you may increase cannot increase the capacity at the cost of the existing infrastructure.
Yes, Millets, what I was doing is there was painting going on. All those things were going on.
Maybe.
So I requested them.
We cannot go there to see what was going
Yes,
on.
plus-
If the report says the joint inspection that additional construction renovation is under progress. Due to renovation work under progress, the required practical lab classes are not ready. The faculty salary payment through cashless mode of transaction could not be produced.
Millets
The
will
team
kindly
members.
see.
You file an affidavit stating that all these
Yes, Millets, I have given my reply. Your Lordship will see.
No, file an affidavit, forget reply. You file an affidavit that the faculty salary payment have been made through cashless mode, one, and two, the practical lab classes were ready. File, you will see.
Yes,
Millets,
Lordship, if I may
given.
take your Lordship to my last annexure, your Lordship, I/3 of my counter
Let him
affidavit.
complete, we'll come back.
In once.
You file an affidavit that you have been making payment of salary through cashless mode. We'll file it. We will see.
Millets. I'll file it. Just to apprise your Lordship, 104 is my reply where I have told them that all these are compliant.
No. Let us see.
Very good.
What do you say?
My lords, I bow down. I'll file an affidavit.
There have been 4 inspections, your Lordship, of their institute, your Lordship. The last one was pursuant to their previous, when they had come before this honorable court. After that, the last inspection had taken place, your Lordship, that is on 9/7. Your Lordship, we see I3, your Lordship, annexure I3, we have even given the photographs, your Lordship, of the condition of the institute, your Lordship.
Condition of the institute or condition of the camera?
Your Lordship, these are all printed. Page 21, your Lordship. I'm sorry, your Lordship. Page 23, your Lordship. That was the report that was submitted by the Principal Industrial Training Institute, Cuttack, who had carried out the inspection, your Lordship. And these are the photographs, your Lordship.
That's
That institute
109.
is
I have also
ready, your
given
Lordship. Renovation work is taking place. And on the third Apex special committee meeting, your Lordship, they held that let the admissions be kept in abeyance for 24-25, and for 25-26, let them take AICT approval and formal approval from them, and they can admit students. But this year, they are not in a position to give the infrastructure benefits to the students, your Lordship. Yes, your Lordship.
Not only this, that faculty salary payment through cashless. So this is one thing. This is one thing which is either correct or incorrect. And no photographs and nothing. So,
And my lords, I have also filed the photographs.
Photographs, if you rely on your photographs and they rely on their photographs, and if there is some difference, then you will have to file a suit.
No, my lords, what I
So that
suggest, I'll file that affidavit first, my lords. Second, I was suggesting, my lords, subject to your lordship's kind consideration. I was suggesting, my lords, if your lordship would direct them to carry out another inspection, my lords, and come back to your lordships can keep this pending. Your lordship will see the inspection and then your lordships can decide. Because I have filed the photographs. At 109, your lordship will see everything is spick and span. So, beloveds, it depends what photographs they have annexed.
Petitioner Institute has been denied approval for admission to post-diploma in industrial certificate course with 30 seats for the academic session 2024-25 based on a joint inspection report conducted also on various dates, including on 9/7/2024. The joint inspection committee had found following deficiencies. :1, the additional construction / renovation of existing building was under progress. 2, due to renovation work under progress, the required practical lab / classrooms were not ready. 3, the faculty salary payment through cashless mode of transaction could not be produced to the team members. Next, Mr. Acharya and counsel appearing on behalf of the petitioner has submitted that the findings are not correct. First off, he has relied on certain photographs of the institute annexed to supplement to the writ petition.
Annexure 13.
Huh?
Annexure 13.
To the writ petition. Stop. Be that as it may, have you stated that because you have filed the writ petition and you are questioning this finding in the report, have you stated in your writ petition that the faculty members are being paid salary through cashless mode?
Yes.
Where?
My lords, I have at para 14, I have referred to my letter of 6/8/2024. In that, it is mentioned. In that letter, it is mentioned. I'll state that on affidavit.
The petitioner filed an additional affidavit, AGA appearing on behalf of the state, refuting the stand taken by the petitioner, has submitted that after 19/7/2023, also the inspection of the college was done. Stop. Reliance is being placed on various photographs shot by the members of the inspection committee to make out a case that the petitioner institute does not have the facilities adequate for grant of approval for the academic session 2024-2024 applications for 30 students. Stop. Let the petitioner file a specific affidavit is taking on oath that the faculty members of the faculty members of the institute are paid salary through cashless mode of transaction for the previous academic session, that is 2023-2024, which shall indicate Sunny. 9/7. 9/7/2024.
24, Your Lordship.
24. 9/7/2024. जहाँ पे है ना
24.
During the academic session 2023-2024. Yes.
Let's just one more submission. In the counter affidavit, they have taken a stand that the admissions are closed since 15th September. Let's 2 days back, there's been an extension, and that I'm placing by way for an additional affidavit. It is there till 23rd October.
Very good. We will take up before holidays.
That's Monday. 7th, would it be convenient? 7th. No, this affidavit relating to the extension, I'm just giving it today.
No, extension, they know better than you.
Yes.
Yes.
If you are giving.
Yes, that I'll file in 2 days' time. Yes, that I'll file in 2 days' time.
Yes.
Obliged.
The affidavit is filed within by Thursday. Let the registry ensure that is scanned and placed on the court.
5.
Oblations.
In item number 5, Your Lordship, the order has been complied.
Complied.
Item number 6.
6, Your Lordship passed similar order. So far, a virus is concerned, I am not pressing my lord. Other prayer listed before the honorable assignment, single judge of assignment.
In item 6, my lord. In item 6, let him file the proper documents.
I'll
That
file
Annexure 2 and 3,
I'll file.
not his appointment orders.
Annexure 2 is my.
Appointment orders of others.
That will single judge will take care of.
That has been annexed.
That will take care of single.
Oh, Lord.
7.
Seven may be taken up for 1 week after, man. So taken up for 1 week after, man.
Why, sir?
Conducting advertise is not well, he has gone to medical. But that is.
Mention. Had you mentioned this matter for early hearing?
I do not know, maybe mentioned.
As requested on behalf of the petitioner, this matter on this. After holiday, yes. Huh? We did this. Did.
8.
8, my lord. This is an intra-court appeal wherein the learned single judge, my lord, has quashed the written examination.
There are 3 appeals. First appeal filed by the OPSC. The second appeal where I am appearing, which are the selected candidate who have not been heard, but by the instance of one person, the whole selection has been held to be legal. So
after appointment.
No.
The appointment was not.
Appointment was.
The learned single judge, my lord, had set aside the written test which was conducted on 19/3/2023.
Oh, that when learned single judge has opined that questions were put.
Yes. Your lordship, rightly, my lord.
All the questions have been.
Yes. So, 200 questions covering 8 subjects. Though the honorable single judge has said that there cannot be questions out of one subject to other. Overlapping of subjects is not possible.
Despite the expert committee.
There is, my lord,
report is there.
Our opinion was.
Judge has held the expert committee report is rather not acceptable.
So all of you are challenging.
Yes, we are all. I am for one of the candidates, selected candidate.
And who is defending?
They have not appeared.
They have.
All right, you should.
Well,
you should notice.
That's to fix a date after vacation.
Yes. It is important.
No.
When do you want?
Any date will be convenient.
1 week you file your requisites. It will come after 4 weeks.
Our leave applications will be also hard along with the.
Because we have filed an application.
That is not a very technical thing.
Yes.
Sometimes subject the counsel who was appearing before this court before the single judge. We can at least try to serve a copy.
Yeah, we can serve a copy on him, my lord, Mr. Mishra.
Let me try, or Dusty Samad so that it can be.
It will
harder.
open.
It will open.
How many petitioners were there? Only one. Learned counsel for the appellants / interveners shall be at liberty to serve copies of the appeal memo / intervention applications.
Not intervention. We have filed independent appeal with a legal.
Writ appeals with. We can do that. We can we adjourn the matter for Wednesday? And in the meanwhile, you just tell him.
Okay.
That will do.
Just
will do
tell
that.
him
That's not Wednesday, only the holiday, Thursday. Yes.
And this
That
case
will be
will
better. So
retain
that
its position.
community can proceed.
And if he accepts, then it's all right. Otherwise, if required, we can. If he declines, then we'll see what can be done.
Yes.
Right.
Let's this matter on Thursday, retaining its position. Yes. These matters on Thursday, retaining their position. Yes. It will be open for the appellants to serve copies of the memo of appeals on learned counsel who had represented the writ petitioner before the learned single judge.
9.
Review petition of my lord's order.
You are seeking review of my lord's order also.
My lord.
Indirectly, you are challenging.
No, my lord. My lord, your lordship may look at your lordship's order and pass an appropriate order.
All right.
I have raised
mistakes.
It is dismissed for laches. So that he has explained in review portal, which is not a ground. Therefore, lordship may, without recording my concession.
All right. Review application has been filed seeking a review of an order dated 11/7/2024, whereby the writ application filed by the petitioner has been dismissed primarily on the ground of delay and laches. And also keeping in mind the conduct of the learned counsel appearing on behalf of the petitioner has argued that the delay and laches taken note of by this court while disposing of the writ petition cannot be said to have not been duly explained. So stop. Next. After having gone through the materials of records and the order sheet of WPC number 22091 of 2023, we do not find any merit in the present review application. Stop. No case of any error apparent on the face of a record has been made out. Stop. No other ground available for a review of an order as order is there requiring this court to review the order. Stop. In our considered opinion, this application has no merit and is accordingly dismissed.
Then we are for the OP number 5 in that review petition.
OP number 5, yes.
May I plead your lordships? My lords, we have approached this court being aggrieved by the cancellation of a tender through office order dated 27/3/2024, which was passed arbitrarily and without justified reason by opposite party number 3. What has happened, my lords, is that we are a experienced A-class contractor and the dispute revolves around. We are the petitioner, my lords.
No, what do you say? Just I missed to.
My lords, we have basically been we have approached this court basically being aggrieved by the cancellation of a tender through office order dated 27/3/2020.
Cancellation of tender notice.
Yes, my lords.
Tender notice, all right.
Dated 27/3/2024, which was passed arbitrarily and without justified reasons by opposite party number 3. What has happened here, my lords, is that we are experienced A-class contractors and the dispute revolves around the construction of Biju Sabha Gruha Library cum Skill Training Center at Nuapara, which was basically undertaken by CMC, opposite party number 5, through its nodal agency OSIC, opposite party number 2. Here what has happened, my lords, is there were 3 rounds in the tender. In the first round, the opposite party number 4 approached us to refrain us from taking part as a person involved with the leadership wanted the contract. So we refrained. But despite this, the bidders who had taken part, 2 bidders, were not eligible and thereby disqualified. So the tender was cancelled. Again, the tender was refloated. In the second round, despite their approach, we participated. And out of the 3 bidders, despite their approaching us not to take part in the second round also, nonetheless we took part.
How do they approach?
Your lordship, they had personal relations, so they had just approached.
No,
We have mentioned the same in the writ petition. Yes, my lord.
Can you prove that? If they deny, if they accept, matter is different. But if they deny, how can you approve? How can you prove that?
My lord, this was what happened, but we took part in the second round.
No, but we are putting this question that if you are saying that they approached you not to participate.
Verbal, my lord's verbal.
Not to participate, all right? If they accept this statement,
Because the chairman wanted to buy. Yes, that is he did not get that credit cash. Not very serious.
They can find them. Huh? Counter.
A copy of the read petition we served because a wrong petition. That what has happened, but the wrong read petition is with me.
File your
A copy of the read petition we served.
issue notice.
I'll serve it in due course of time, my lords.
Notice. We are issuing notice not because of the because your case has merit, but because you presented the case so well. Issue notice, accepts notice. 4 weeks?
Yes.
Nata कौन?
Arpita Mahapatra.
Natalie. Please. Natalie. All right.
11.
In item 11, I'm for the intervening. In item 11, I have filed a petition for intervening this.
Be here. Yes.
Please for the petition.
Report along with the photographs and audiographs notes. Now I find that in the old writ application, there has been a number of orders and reports and affidavits filed by the authorities, and they are in the same line also. Now I find that almost no change, but rather some additions are there. But constructions, encroachments were there, but some new construction to come up. But so far as cave number 8 and 9 is concerned, it has been recorded as Bara Bhuji cave. It's meant for Sarvasadharan, means for general public for worshipping 8 and 9. That is the record of right source. And at the top there is also one giant temple. It's even though it's a cave, but there is a giant temple which is also worshipped by the giants at the top of the cave. But
Top, above the cave or above the hill?
on the top of the hill. That report is also, there are some additions to that temple because initially it was a small temple, but some marble constructions and they've done on their own. But admittedly, since 2002, there has been reports that encroachments are there.
Serious encroachments, completely shadowing the area. So,
Find this in person, no? Find this in person?
No. On behalf of one Sri
It's a council.
Khandagiri Udan Digambar Society, it's a trust, I think.
Monument was dazzling from a distance.
Where is your report?
But we had submitted before the registry, percent of
Report is
direction along with the pen drive and other things.
Your report is there.
Pen drive region,
That yellow cover, I think that report is there.
I'm filing two other, I'm for the intervener. I'm filing two other, which would be clarified that the area which the petition is occurred, only 5 decimal. I have no objection that any improvement made that in the aforesaid area, only in 5 decimal, anything they made there.
What is your IA number?
Yes, Lord.
What is your IA number?
IA number 1330 of 2005. 05 of 2024.
IA number?
13005 of 2024.
It's there.
IA number 13005 of 2024. This application has been filed on behalf of the applicant seeking intervention in the present writ application in the nature of public interest litigation, which relates to the encroachments caused in, what is that area? Caused on the sites of Khandagiri and Udayagiri.
It's only Khandagiri, Milords. Udayagiri is on the right side. We had not, there was no direction, but Udayagiri is all right, Milords.
Khandagiri is in the district of
Khurda, Milords. Bhubaneswar near
the district of Khurda. Stop.
Near Bhubaneswar is fine.
Mauja Jagamada, it will be approved.
Inside Bhubaneswar.
Outside Bhubaneswar, Lord's message.
The
It was very now in Bhubaneswar.
intervention, the intervener applicant asserts that no, who are you?
I'm for the Ma Barabuja Temple Managing Trustee. The cave number 8 and 9, I am looking after the said.
So you are looking after or you are enjoying? What are you looking after? There are so many encroachments.
The temple, the 2 temples.
Therefore, why, what interest do you have in this litigation?
Yes, Your Lordship. I am for the cave number 8 and 9. The cave number 8 and 9, Ma Barabuja temple has been situated in cave number 8. And in cave number 9, Sri Mahavir temple is situated. To protect the same, the Jain temple in the view of letter number, that is by my annexure IPC, page 12, they have collected the instruction to repair the Jain temple. But instead of repairing, they are demolishing all the structure, for which I am before your court, Your Lordship.
You want to do what? You want to protect?
Yes, Your Lordship.
You leave the place. You leave the place, we will ensure protection.
Your Lordship, the
Please leave
temple.
it. What time will it take for you to leave? We will ensure protection. You are worried about the protection. We will ensure that.
Your Lordship, there is a temple situated. Lot of
all the encroachments will have to be removed. Not even a single encroachment of any nature.
I am not in
either permanent or temporary.
Your Lordship,
shall remain there.
Your Lordship, kindly see the report of the Archaeological Survey of India, Your Lordship. ASI.
No, it is not a report of any ASI. It is a report submitted by Mr. Samantara and Ms. Patnaik.
We decline to entertain
that
this intervention application, as this proceeding is confined to the encroachment surrounding Khandagiri Caves. And around, so it must be forest, it must be this thing. So how can there be any encroachment in and around Khandagiri Caves? Stop. This application is dismissed. Stop. We make it clear that we shall confine in the present proceeding the issue of encroachments in and around Khandagiri Caves unauthorized encroachments in and around and may pass appropriate orders for removal of unauthorized encroachments in accordance with law. Full stop. We also make it clear that if by the action of any authority taken for removal of encroachment in accordance with law grieves any party, comma, it shall be open for such party to take recourse to appropriate forum as available. Stop. This court shall not entertain, comma, in the present proceeding, comma, in any intervention application issuing, raising any issue of a removal of issue against removal of encroachment by the authority pursuant to the orders of the court. So stop. This application is accordingly dismissed. If you want to leave the place, you can leave it.
Your Lordship, my petition is not for that. I am just before your Lordship that any development may be done by the petitioner in the aforesaid area. I have submitted the RO, copy of the RO, in which your Lordship have kindly glance 1 minute only.
Now, if you have any right, then you have separate cause of action.
If you have any right, and if your right is likely to be infringed because we pass certain orders, then you shall challenge that order. Not our order.
No, I am before your Lordship. Any order your Lordship may pass deemed fit and proper. I am not on that. I am just placing one thing before your Lordship. Just the RO which has been prepared, I have submitted before your Lordship.
We will not see. We will not see our system.
What happened to that?
The area which has been
That we will see.
obliged.
That they will put that we will see, not a problem.
Only anything any order your Lordship may pass.
No, we will not hear any intervention application. Now we next. Where is the report?
The order
There at page 94.
No, there. 94, it's there.
That must be the pen drive. Yeah.
That is pen drive.
Pen drive inside that notes will be in it.
Such a big envelope.
monument.
Where is your report? Your report is in pen drive.
No, written, but pen drive given the videograph and photographs.
WC 19.
19184. There is
One nine.
After that, next page, please. Yes.
Pursuant to the court's direction, a joint report has been submitted based on site inspection conducted by Mr. L. Samantray and MS Suman Patnaik, comma, as officers of the court. Full stop. The That they have also submitted to this court a pen drive containing the details of the videography and still photographs of the area in question. Stop. Who is the head of ASI here in Bhubaneswar?
I think their assistant director is there, not so, because
Mr. Padi.
Who heads the ASI, Mr. Padi? Mr. Padi, who heads the ASI?
My lord, yes, my lord, my lord. Yes, my lord.
Who is the topmost officer of ASI in Bhubaneswar?
The superintendent, SI, the
Superintendent. Next. The encroachment, unauthorized encroachments caused in and around the caves, which are of immense archaeological and historical importance. Is a matter of very serious concern. Stop. No. Personally present. Which requires immediate attention before the situation worsens further. Stop. Let a copy of the report, let copies of the report and the videography and the photographs available in the pen drive be supplied to the district magistrate Khurda, the superintendent of police Khurda, and the superintendent archaeological survey of India, Bhubaneswar.
Sir, Bhubaneswar.
India.
Bhubaneswar.
Of India, superintendent is there in Bhubaneswar?
yes.
Yes. There is a post in Bhubaneswar. Yes.
Must be there.
Now another is created in Puri, but it is Bhubaneswar.
All right.
Stop. By tomorrow. That shall be tomorrow. So supply of the pen drive, supply of the report and the pen drive to the concerned officials shall be ensured by Mr. L. Samantray, Land Counsel for the L. Samantray, and Mr. L. Samantray, bracketed for District Magistrate and Superintendent of Police Khurda. Khurda is superintendent or is
Superintendent of police.
Khurda?
But your lordship may say DCP because it's within the
DCP, therefore DCP.
DCP Bhubaneswar, my lords.
DCP Bhubaneswar. Khurda is
District Magistrate Khurda, but DCP Bhubaneswar.
DCP Bhubaneswar. वहाँ पर खुर्दा लिखा है और DCP Bhubaneswar. And Mr. Padi, Deputy Solicitor General for India, for the Superintendent Archaeological Survey of India. So, let's this matter on 8th of October, on which day the District Magistrate Khurda, the DCP Bhubaneswar, and the Superintendent Archaeological Survey of India, Bhubaneswar, shall be required to be personally present in court with their proposed scheme for a removal of encroachment from the concerned sites. So, from the site in question, First off, the court, they expect that before they appear before us on 8th of October, they hold a meeting to chalk out a plan for effectively assisting this court. 10:30 8 on 8:30 AM. Yes, you can do. They will be seeing the reports. They can meet. They can prepare a scheme.
Yes.
They can tell us that this can be done, and if required, we shall be issuing directions. But in no case the encroachment is going to be tolerated, either permanent or temporary.
Yeah.
Pen drive, है ना? You just keep the
pen drive and copy it and supply to them.
You have a pen drive or
No, one
this you have supplied?
report should be quoted. Report we are quoting in the order.
Yes, sir.
Report quoted.
In fact, sir, GA department, so also the municipality has to be, they will check out, they will, because earlier,
what the statute provides, section 19 of the Monument Act, section 19 is there, the SA authority should issue a notice. Basing on that, the state government should act it up and evict this. This is the law.
So therefore, Mr. Padi, we have taken care of everything. We have directed this district magistrate, the DCP and the ASI people to sit together and to chalk out a plan and then to tell us what are they going to do. If required, we shall monitor, we shall pass appropriate orders. But one message must go. One message must go. And that should be from the officers as also from the court, that in no case any encroachment of any nature is going to be tolerated. Yes.
Welcome. Obliged.
12.
Hello, item, may I please? Yeah, my lord, this is filed.
Yes.
My lord, may I take your lordships directly to page 66, annexure 19, the cause of action, my lord. Annexure 19. My lord, the allotment letter was issued for allotment of a shop room in the premise of the MKCC medical campus, my lord, to the petitioner. Pursuant to the direction of this honorable court, petitioner filed a representation, it was considered, and thereafter this letter has been issued on 7/2/2024, my lord, wherein he has been allotted a ground floor, my lord, and he was requested to be present in the office of the undersigned for execution of necessary agreement in this regard at an early date. So, my lord, thereafter he has been approaching and repeatedly pursuing the authorities. They are not taking any action, my lord. Since 2005, he has been pursuing the matter.
So where is the advertisement?
My lord, advertisement tender is at annexure 2, my lord, page 21. Clause 3, if your lordship may kindly refer to the tender paper. There, my lord, preferences were given that to give first to the unemployed youth, then to the physically handicapped, and then to persons whose annual income is less than 25,000 per annum. He
What is
falls
the
under
date?
third category, my lord.
What is the date of?
My lord, date is there,
20 years.
page 23, your lordship may see. Page 23, the English part, my lord, 10/10/2025.
So this has no purpose.
Oh, my lords, already all rooms are already available, and the matter has been settled pursuant to the intervention of this honorable court. Only a lordship, annexure 19. He has already been allotted also the room. Only they are not executing the agreement. That is my grievance, my lord. If they will execute the agreement and possession will be handed over, then my lord's prayer of the petitioner will be retraced, my lord.
20 years, what have you been doing? Not in,
None of the rooms have been allotted, my lord, to anyone.
Nothing since these 20 years.
He has been pursuing the matter, my lord. He is a very poor person for allotment
that's
of a
what I'm
fruit juice
surprised.
parlor.
These 20 years, what has this person been doing?
Lord, just my lord, just pursuing, and he is marginal family, is belonging to marginal family, and only
That
my
is
lord.
what, marginal family doing nothing.
That is the only grievance, my lord. So they take instruction, my lord. OP3 is the, my lord, contesting superintendent of the MKCG Medical College.
I said, good tell. That may help.
Only I pray if notice may go, my lord, they may take instruction, my lord.
Yes, seek instruction. Yeah. Yeah. Yes. Does this matter on after vacation? So as to enable Mr. Samantraya and AGA to seek instructions and file affidavit if so required.
But
Yes. 23rd.
13.
May I please, your lordship?
That's why it is better. See.
Whatever they say that.
Yes, well, that.
May I please, your lordship? Pursuant to a tender call notice, both the petitioner and the contesting private opposite party, 567, they put their tender. And all the parties quoted the price less than 14.99 and between 15%. Therefore, they allowed the opposite party number 6 as L1. Therefore, the petitioner had filed a writ application before this honorable court, and this honorable court directed, taking into consideration clause 21.1 and appendix 23-36 of the OPWD code, if within the zone of consideration of 14.99% and 15%, more than one bidder comes, then it has to be settled through a lottery, which shall be conducted in a transparent manner. That was the direction of this Honorable Court. Despite that, they declared again the opposite party number 6 as L1, for which the petitioner had filed a contempt petition, and your lordship permitted me to file the said action by challenging a separate writ petition. Now, same order has been passed under Annexure 8 as 7/6 on 7/6/2024. Before that, I will take your lordship to the relevant clause of the NIT. That is
No, but where is the order of this court?
order of the court. I have quoted at paragraph 14.
No, no, where is the order? Where is the court?
Paragraph 14, relevant portion is at page 11, paragraph 6.
Relevant.
Paragraph 6, madam. No, page 11, the ordering portion, paragraph 6. Considering the contention raised by the Land Council for the parties and after going through the records, this court is of the opinion that the order dated 9/4/2024 under Annexure 7 passed by the opposite party number 3, Engineer-in-Chief Rural Water Supply and Sanitation, is liable to be quashed and is hereby quashed. Accordingly, the matter is remitted to the very same authority to adjudicate the same afresh and pass appropriate order, taking into consideration clause 21.1 of the notice inviting bid and under clause 36 of Appendix IX of OPWD Code, Volume 2, as expeditiously as possible, preferably within a period of 2 weeks from the date of production communication of the certified copy of this order. Then I will take your lordship to clause 21.1. 21.1 is at page 50 of the brief.
What is 21.1?
21 point how to determine who is the lowest price bid.
So where is that?
At page 50 of the brief. Let me place. Department shall open and compare the price bid of all techno-commercial respective bidders to determine the district-wise lowest price L1 under RFP, provided the lowest price is reasonable and if the rate quoted by the bidder is less than 15% of the tender amount, then such bids shall be rejected and the tender shall be finalized basing on merit of rest bids. But if more than one bid is quoted at 14.99 within bracket decimal up to 2 numbers will be taken for the practical purposes less than the estimated cost, the tender accepting authority will finalize the tender through a transparent lottery system where all bidders, their authorized representatives of the concerned CDO, COM, EO, Jilla Parishad, so and so will remain present.
So whether this has been
They have
applied?
not done this. In paragraph 7, I have quoted what is the percentage of rate which has been quoted by respective parties. Here, paragraph 7 of the writ petition.
Yes, state.
My lord,
Yes.
page 7.
Do you have a copy of the writ petition?
Yes, Lordship, can you come to page 123?
So your only point is that all the three bidders
My lord.
had quoted 4.99
14.99
4.99
to 15%.
to 15%.
My lord.
And therefore, they were required to follow this procedure 21.1.
Okay.
Please, they have not followed. This is the only
Yes,
point.
this is the only point.
Yes.
So it has been followed, but Lordship, kindly come to page 123 for page 123. Serial number 17. Petitioner is with respect of Keonjhar district, Milords. It's for the whole district, it's Keonjhar. If a loss will come to Milords, column number 1, 2, 3, 4. Quoted amount of L1. Responsive bidder with calculated percentage. Milords, it's 30592908.86. Whereas others, not quoted amount of other bidders found to be equal to that more than 49% is not more than that.
Where are you reading? This is, you are reading Keonjhar.
Keonjhar Millers.
So Keonjhar one is less than 14.99.
Yes.
And the others?
All are 14.99, but there is a method called BOQ. On that basis, they have calculated the price. That is not elaborated here. If you will see the column number 4 at the top, quoted amount of L1, responsive bidder with calculated percentage rupees. If you will also come to 17, 30592908.86.
Where are you reading?
Keonjhar, column number 1, 2, 3, 4 Millers. Keonjhar in the same line, it's Millers 30592908.86.
Yes.
That is in respect of L1. So far as others, if you will also see, it is 30594527.51. Excess amount in comparison to responsive bids is 1618. That is why he has been selected.
No, that is immaterial. That is immaterial. 21.1 specifically says that if the prices quoted are below 14.99 to 15, then you will have to follow.
Go for lottery, Millers.
Lottery.
But yes, Millers.
If you have this case that the price was above 15%, then the matter is different.
But here in paragraph 12 of the order,
In respect of one candidate, he had quoted 18%. They had declared him as L1, and subsequently on our objection, it has been rejected.
How can that be? Yes, rightly rejected.
No, they've stated that the rate at BOQ method. I will file that response how they have come to this conclusion without going for lottery. That affidavit will be confined to 21.1 only.
Yes, that is the entire case. That is my case.
One counsel appearing on behalf of the when counsel appearing on behalf of the petitioner has drawn this court's attention to, which is that page 21.1?
Page 50.
Page 50.
To was 21.1 of the tender notice, which lays down the procedure for selection of L1 when
which is the page?
50.
Page 50.
Page 50, second column, lowest price bids. It's
But for more than one bid is quoted 14.99, decimal up to 2 decimal will be taken, less than the estimated
procedure when more than one bid is quoted at 4.99%. So he submits that in the case of that in the present case, the petitioner and two other successful bidders had quoted bid at bid at a rate between 14.99% to 15% to less than 15% of the tendered amount. And and therefore the authorities were under obligation to finalize the tender through transparent lottery system, which has not been done. First off, on that ground, the selection of opposite party number 6 as the L1 bidder is being challenged in the present writ application. So the notice will go. Right. So the issue notice. All right, let me explain first, please. Before issuance of notice to respond opposite party number 6, we consider it apt to have the stand of the state opposite parties on record. So for the said purpose, let a counter affidavit be filed on behalf of opposite party number 1. 3 weeks after holidays.
Only addition, your lordship dictated 2 other candidates, in fact, petitioner and 3 other candidates.
3 other. There are 4.
4. Can I pray? Similar 3 matters are there.
Where?
In this, challenging the same order.
We can take up all the matters. Where are they?
Not listed. Not listed.
Make a mention.
Even the numbers also.
Oh, right.
After holiday.
And 43. If your lordship pleases, my lord, anytime before your
Yes, for the other side.
My lord, the state.
State.
My lord.
All right, I'll see. Please wait.
Grateful.
May I, with the lordship's permission, mention item 24 in the fresh cases list, my lords. Others, I've come all the way from Delhi for this case, my lords. So if your lordship pleases, could it be taken up today, my lords?
24 will not be taken up otherwise. It will be taken up.
Please, your lord.
Wait.
Do we have anything at 2 p.m. to take?
No.
No problem.
I don't know, 14.
May please, your lords. But the petitioner and the OP number 4, both are bidders under annexure 1, lord, the request for a proposal, my lord. That is for operationalization of mobile medical vans, MMB, in Sundargarh, Odisha, under DMF Sundargarh. There is a clause in the annexure 2, my lord, at page 33.
Annexure 2 is all right. Yes.
Page 33, my lord. Responsibility of the selected bidder. Subclause 2, procurement of the MMB, equipments, installation of equipments and GPS vehicle tracking devices and software. The vehicle should not be more than 1 year old from the date of manufacture on the day of commencement of service, my lord.
Yes.
The service provider would procure all necessary road and goods permit for the MMB and maintain the same throughout the period.
Yes.
The OP number 4 was selected as L1, my lord. And from the day of commencement, he has used the vehicles which are 6 to 12 years old, and for which I have filed a representation before the OP number 3, because it violates to take steps as per.
Who are you?
I am also a bidder, my lord.
You are a bidder, but you are unsuccessful.
Yes, my lord. Only because keeping in mind the use of old vehicles, he has quoted less, for which
might have quoted less, but he was successful. Now he is committing fraud.
He has committed fraud.
Yes, he is committing fraud. Then there is a action can be taken.
Yes,
but you cannot be awarded. So what?
No. I am not praying for award, my lord.
Then what for have you filed?
I have filed a petition before the OP number 3 to take step as per clause 20 of the RFP. That is pending since 2 months, my lord.
Maybe. Where have you said that he is using old vehicles?
Yes, my lord. That is at I filed page 40, Annex 3, my lord. The relevant person is 42. I have mentioned the unit in the table, my lord. All are 6 to 13 years old.
And when they submit the bids.
No. Where have you stated on affidavit? No representation.
Yes, my lord. That is at paragraph. Para 5, my lord. The first subpara, it is necessary to mention here that with an intention to use their old vehicles into service and to reduce the capital expenditure, the OP number 4 had quoted less in their financial bid and successfully selected in the process. Because after being selected, the OP number 4 is using old vehicles which are 6 to 18 years old, thus violating the precondition of the RFP, which
What
are
is
part and
16-year-old on what basis?
My lord,
on what basis you are saying this?
I have filed the details, my lord. In the
details at the number.
At page, well, yes.
Number of the
vehicle,
vehicle.
yes, vehicle number also there.
Where is that?
Page 40.
You have said you
Page 42, my lord, with vehicle numbers, my lord. Vehicle registration number, name of the CHC.
Where?
Page 42, my lord. Running page 42. Year of manufacture, registration date. The name of the block where used.
Yes, who is for the state? Yes.
I've got an instruction on this code.
Let's say 5, 6, 7.
It's a very serious matter.
Yes, please.
And all the vehicles have come from Madhya Pradesh.
All from Madhya Pradesh. I have given the photographs, my lord. All old vehicles from Madhya Pradesh and no state permit.
What allegation have you made against OP2?
OP2 because on the letter which addressed to OP3 with the copy to OP.
Paragraph 8. Paragraph 8.
My lord.
Okay, you are saying
because
that,
because
okay.
collector is the chairman of the district mineral fund.
Got it.
And the DMF fund is used for this purpose.
But you have given 20 out of 25. So
Yes.
record they may be having those 5 vehicles which are new.
5 vehicles I don't have seen the 5 blocks, my lord, but 20 information I collected.
So as per the tender, how many vehicles do they have to give?
For each block, my lord.
Each block 1 vehicle?
Yes, minimum 1.
Considering the nature of allegation made in the present writ application, comma in public interest, comma we direct in public interest the who is health secretary? Health secretary or principal secretary?
No, so in fact, they are nowhere connected. It's similar to see 2 and 3.
Who is 2?
Collector and CDMO, those who have floated the tender and finalized the tender.
Collector and CDMO
of Sundargarh
district to file their separate counter affidavit dealing with the statements made in the writ application, comma, paragraph wise. So stop. List this matter on 9th. Within first 5 cases. In the meanwhile, counter affidavit must be filed.
15.
And
the order of the opposite part number 2, that is under annexure 6, refusing to extend the tenure of the contract for the period lost due to COVID-19 pandemic. That is the subject matter of challenge, my lord. Here, my lord, the petitioner was awarded, she was awarded with the contract for 5 years, and agreement was entered into under annexure 1, that is a master license agreement for the period from
You could have
3/7.
filed a suit. Why writ petition?
Pardon, my lord?
You could have filed a suit. You are applying the doctrine of force majeure. For that, you could have filed a suit.
No, my lord, what happened in this case, my lord? Your lordship may come to annexure 6, page 43. On the last moment, they say that your period has been extended for 90 days, invoking the provision of force measure that is provided under annexure 1. And though the pandemic period was longer one, that is from, if your lordship look into my representation, the period is from 22/3/2022, 31/7/22. That is the official. And that very same benefit was extended under annexure 7 to another person who was allowed to operate stall at Khorda Road. She was allowed to operate the stall at Bhubaneswar railway station. And my lord, they say that two things, that there is no provision under the 2017 policy for renewal or for extension. However, invoking the provision of force measure, it was extended for a period of 3 months in your case. But the another authority, that is under, if you look into annexure 7, page 45, the another authority, that is Indian Railway Catering and Tourism Corporation, they extended in another case.
That is another authority. The state government might
under
have
the railway, my lord. They are all guided by the railway code. And another aspect, my lord. So there is no personal allegation against me. They only ground they extend, they refuse to extend.
That is
that
not
there
the
is no
question.
provision.
See, you cannot rely on the decision taken by a different authority.
No, my lord.
And they say you have opened the shop.
Very same platform, my
Mr.
lord.
Mahanti, you opened the shop and paid license fee. That is what the impugn order says.
Right.
That means you have opened the shop and we are operating it.
And my lord, that is valid up to the extension period was valid up to today is the last day. And the auction which was held on 2nd, I have filed a miscase 12095 second miscase, my lord. IA. There I have said that there has been failure of auction, my lord. So there is no one has been awarded. My humble submission before your lordship is that, my lord, once you have extended the same benefit to another person in Khorda Road railway station, why I should be deprived? That is the only point.
Dismissed.
The contract period was for the 5 years, my lord.
All right.
And also, my lord, railway code, I have the railway code 712, clause 712 renewal. It says that it can be renewed. That is contrary to their stand in the impugn order.
There is difference between can be renewed and the court directing to renew.
Or
If
my
the
lord,
court directs, then it shall be renewed. It should be, it shall be renewed.
well, my submission is that that period, at least that benefit,
That period you can
that
file
is,
a
that's a discriminatory.
There is no discrimination, Mr. Please. A has taken a decision. B is not the same authority. B is
under the railway.
Under the railways, therefore, if under state of Odisha, one collector takes a decision, then other collectors shall be bound by that decision of the collector.
No, my lord, I am
because
not,
both of them are under the same.
my lord,
Why,
my
you
humble
appear to
submission
be
is that,
such
my
a
lord, it's not a
reasonable
question of
counsel, and how can you
negative
make-
equality, because it provides, it is there in the.
Equality, we understand equality. All right, next.
Then I may be permitted
16.
to move the authority, appropriate authority to reconsider the matter, my lord. Liberty may be granted.
Permission to withdraw this application with the liberty to approach the competent authority, raising the grievance which he has raised in the present writ application. Said application is permitted to withdraw with the liberty as sought for. Yes.
We have put the railway, my lord, the appearance be noted.
Yes, railway.
16.
Yes.
May I please approach?
Milord, the issue related to Milord, two issues, Milord. One basically, Milord, the regarding block of my portal registration to participate in the tender process, Milord. Milord, there is a guideline to block the portal registration to participate in the online bidding if the license is cancelled or suspended or I back out from the agreement. Here I have to deposit additional performance security 22nd July 2024. And the petitioner admitted prepared in 24 July, just 2 days after, your lordships.
What happened?
Milord, I have to deposit additional performance security by 22nd July 2024. And I prepared the same only 24/7/2024, submitted 25th, Milord.
Yes.
Milord, the contract was cancelled. I have not, Milord, now they have retendered, got to order. Now they have blocked the portal block to participate in the procedure. The guideline provides there must be inquiry, specific show cause notice, which has not been followed.
No, but what inquiry?
Inquiry about what is the delay, reason of delay, Milord, why? Because I have submitted because
the delay is admitted.
No, delays I have submitted a medical certificate, Milord.
Medical. So is there any exemption?
Yes, I have annexed that medical certificate. Second,
No. Whether that can be a ground.
no, not
relaxing.
Your lordship, then show cause notice, Milord. So
No. Where is the show cause?
the guideline itself provides, Milord. Guideline itself.
Let us see.
Your lordship. Your lordship, page 91. The guide.
In case you're disputing that you have.
Your lordship, so one order that clear intention to blacklist any order. That I have, your lordship, recent order of your lordship.
There is no question of blacklisting. Where is the guideline?
Page 91, sorry, Milord. Page 19, clause 23. Page 91. You start from, sorry, Milord. You start from guideline, which is part of the bid document, your lordships. Start from 84, but the relevant is, Milord, 91, your lordships.
Yes.
Your lordship, may I permit it, please? If the registration certificate of the contractor is cancelled, Milord, suspended by the registering authority, blacklist by the competent authority, his portal shall be blocked automatically on receipt of information to that effect. We are not, Milord, my license has not been cancelled, Milord. Second, your lordships. If the portal registration blocked on the ground mentioned in the above para 23.1 shall be unblocked automatically on receipt of the revocation order of cancellation or suspension, blacklisting from the concerned authority, Milord. Then 3.3, Milord. The officer inviting tender shall make due inquiry, Milord, and issue show cause notice to the concerned contractor, who in turn shall furnish his reply, if any, within a fortnight from the date of issue of show cause notice. Thereafter, the officer inviting tender is required to issue an intimation to the defaulting bidder about his unsatisfactory reply and recommended to the chief manager for blocking of portal registration within 10 days of intimation to the defaulting bidder regarding unsatisfactory reply with intimation to the registering authority and concerned chief engineer, head office, if any, in the following provisions are violated, Milord. Lord, first of all, my humble statement, my license has not been cancelled, Milord, and nor suspended. Then, your lordship, 25.3.2, your lordships, 23, your lordship, 23.3.3 fails to execute the agreement stipulated time, Milord. I have
No, 23.3.1.
23.1 not apply to me because my license is not cancelled or suspended, Milord.
Fails to furnish original thing, instruments, tender papers, CMD, bid security that you have given. Whatever is there in the bracket.
Yes, that has been, Milord, the stage is over, Milord. Here the performance security after, Milord, selection of the tender process, Milord.
Instruments. Backs out from the bid on any day.
Your lordship fails back out bid any day after last date of receipt of tender till expiry of the bid validity. This is not will apply because there is already I have not back out, Milord. I have already price bid was open. I submitted the only 2 days delay of, Milord, deposit of additional performance security, and before any
Only 2 days. Forget only. You have not submitted the performance security in time.
Yes, Milord. They have, Milord, prior to take a decision, they cancel and retender, Milord. Regarding on the same day, your lordship kindly have impugned order, your lordship, annexure 1. Sorry. My lord, as plus 20.
26. 26.
26. And then they have exercised under your lordship 23, your lordship.
Okay. These are amendments.
Yes, sir.
Yes, who is for the estate?
Yeah. He will be covered by that, 23.3.3 minutes. Fails to execute the agreement with the stipulated date. He was selected. He was called upon to submit the APS.
No, see, this is not happily worded.
Exactly, minutes. I think these are all independent provisions.
23.3 ought to have been somewhere after 23.3.4. Because the 23.3 stipulates issuance of notice or something.
Yes.
See, these are the grounds for blocking of portal registration.
Right.
23.1, 23.2, 23.3.1.
3.2, 3.4, all are yours.
So 23.1 is automatic, no notice required.
Yeah.
23.2 unblocking, so that is also different. 23.3.3, if you have done, you should have given him a notice. So no notice was given. Tell us by tomorrow what happened. Whether you intend to unblock or. Tell us tomorrow by tomorrow.
Yeah.
If required, we can direct you to file counter affidavit. We will not pass any order.
Yeah.
Just seek instructions.
Yeah.
Whether notice is required or not. If the notice is required, whether notice was given or not.
The only thing is that whether 23.3.3 shall be read with 23.3
Get instructions and tell us.
That you get instruction.
Yeah.
See, if you can take a stand that no so-called notice is required,
That's
let's see what.
Please.
As requested. List this matter on tomorrow.
17.
May I please, Lordship?
What is the CMAPL?
In fact, Lordship, earlier the petitioner had approached this honorable court, and due to Lordship non-compliance at particular order, because in course of day it has to be, first requisition had to be filed with correct address. Because he could not, Lordship, got the correct address, that's why it could not be filed. That's why automatically it has been, Lordship, dismissed.
Then what is WPC 10832?
10832, Lordship, that writ application that has been dismissed, Lordship. This
So you have filed a fresh writ application.
fresh writ application.
Instead of restoration.
No, Lordship. Restoration is, Lordship, filed to restore the petition 10832, Lordship. That restoration.
So you want to press 2 writ applications.
But now the second, Lordship, if it is restored, Lordship, then
Then this one is not required.
perhaps not required.
I
Because
think there is a similar writ application.
similar writ application, but the consequential
just
action is
make
under
up it.
challenge, Lordship. Subsequent action is under challenge by this honorable court in second writ application.
I think that you did not appear, so it has been adjourned to a distant date.
No, no,
Similar one, another name.
no, Lordship, that is not. That is separate, different application, Lordship. That is in minds matter, Lordship.
Similar grounds, not this one.
Not this one, Lordship. Not this one, Lordship. It was before, Lordship, because Lordship, on perusal of the CMAPL application, because I have filed another CMAPL application, that's why Lordship directed it can be listed along with that writ application, so that both the writ application can be considered. Lordship. But the Lordship can get over the second, the present writ application, so that Lordship will be.
CMAPL number
Lordship.
CMAPL 299 of 2024. This application has been filed for restoration of WPC 10832 of 2023, which is to dismiss for default for non-compliance of preemptory order.
Lordship, Lordship,
Preemptory order
3/7/2024.
dated
3/7/2024, Lordship.
3/7/2024. and counsel appearing on behalf of the petitioner has submitted that the default in filing the requisites on the same day, that is 3/7/2024, was neither intentional nor mana fide. Full stop. Have you complied with the notice?
Lordship, I have already complied, Lordship, deposit requisites have filed.
Stated that in compliance of the said order dated 3/7/2024, passed in WPC number 10832 of 2023, the requisites for issuance of notice to opposite party number 6 have since been filed. To stop considering the facts and circumstances, this application is allowed. Let accordingly, WPC number 10832 of 2023 stands restored to its original file. IE number so and so stands disposed of. The IE has stands disposed of. Same. There.
1812.
What is that? Next, there is WPC number 21812 of 2024. There is an apparent typographical error. The order dated 23/9/2024, in as much as in the first line of the second paragraph, quote unquote, this has been typed in place of quote unquote the. The said order shall be read accordingly. Yes.
Lordship, kindly say, here is the case, Lordship. Lordship, kindly come to.
Yes, I think the Lordship restored the same. Now the original writ application should be considered along with this, because here in the subsequent writ application, all pleadings have been made after dismissal of that writ application. So
And consequential order, Lordship.
No. Same order or another order you
Another order has come up, Lordship. In the minute, another order has come up.
So you have two options.
Lordship.
Either you withdraw the writ petition, the first writ petition, or if you want both the writ applications to be heard, we will have to fix a date for hearing of both.
Then Lordship can fix it so that subsequent documents can be, Lordship. I can place, Lordship.
List this application with WPC number so and so for admission on 29th of October.
In fact, Lordship, they have issued later, Lordship, they have taken a third party, they're creating third party interest, Lordship. If my interim order will be restored, then I don't have any objection, Lordship. Otherwise, they will, Lordship, they will hand out the work to others.
What was your interim order?
Interim order, Lordship, Lordship can come to my same appeal application. I have quoted that order, Lordship. At running page 6, Lordship.
So the other side had appeared in that case.
In that case, they have appeared, Lordship.
Then CM.
But Lordship, now what they have done, Lordship, there are 3 participants.
Just a minute. Whether in the proceeding the other side had appeared, whether it had appeared or not.
In that case, Lordship.
उसको काट दो order को CMAPL. Issue notice CMAPL. You will have to issue notice to
So Lordship, my humble submission is the fresh writ application, which is because I have in this writ application, I have challenged the subsequent action.
Maybe everything will have to be, first of all, the other side will have to be given an opportunity. What we have done is that you got an interim order.
Now that is
Just a minute, you got an interim order.
Lordship.
After that, you got the writ petition dismissed for default.
Lordship.
In that case, the other side was appearing.
Lordship.
Now, you want the writ petition to be restored.
Lordship.
That cannot be done without hearing the other
That's
side.
Lordship.
You want the interim order to revive. That cannot be done in their absence. And you want an interim order in the present proceeding. That cannot be done.
Now, my humble submission, Lordship. Lordship, can Lordship?
We should be fair to each other.
No, Lordship. 1 minute, Lordship. But Lordship, grant me only 1 minute line. There are 3 participants, Lordship. The petitioner, Lordship, along with other 2. The person who is appearing in the writ application has filed the counter, Lordship. While allowing me, because Lordship, I was the successful bidder, and they issued me a letter of acceptance, Lordship. And after opening of price bid, they issued me a Lordship letter of acceptance, and Lordship, by rejecting the bid of the opponent, Lordship. And subsequent stage, Lordship, he was initially disqualified, and subsequently, without my knowledge, they qualified him also, Lordship. Then, Lordship, I had met party to him, and he has already appeared. Now, Lordship, after taking up advantage of this order, they also disqualified him. And now they have created a right in favor of opponent 3.
Yeah, that can be done. See, you are considering your case from your perspective.
Lordship.
We are considering the entire case from the perspective of the procedure.
Lordship, that's true,
which is to be adopted.
Lordship.
And that procedure must be fair. He has a right to be heard.
No, that's true, Lordship.
He did not dismiss your writ petition.
No. No, Lordship.
He did not dismiss.
No. No, now
we also did not dismiss your writ petition.
No, Lordship.
It got dismissed because of you.
Lordship.
So therefore, you will have to suffer.
But Lordship, no, that's true. But now, Lordship, my grievance, Lordship, against OP number 6, who is not a party in that writ application. Lordship, he is not appeared.
We don't know. So you don't press it. You don't press CMAPL. We will hear you.
Lordship, that's my submission. CMAPL, Lordship, I can, Lordship.
Learned counsel appearing on behalf of the petitioner does not intend to press CMAPL number so and so. The said application stands dismissed.
Lordship, then press writ application, maybe, Lordship.
When do you want?
Lordship, today is about Lordship. His urgency there. Lordship,
yes.
Lordship.
All right.
Lordship, kindly come to page 24 for a moment. Page 24, Lordship.
Yes.
Page 24, Lordship. The tender was floated on 9/2/2023, Lordship. Yes, page 24.
9/2/2023,
Lordship. Last February, Lordship. In the meantime, more than 1 year.
24.
23, Lordship. 9/2/2023.
Yes.
Then, Lordship, kindly come to next page, 25. The date of opening of technical bid was 2/3/2023. That is, Lordship, page 25, next page, Lordship.
Yes.
That was 2/3/2023. In view of this technical evaluation, Lordship, Lordship, kindly come to.
No, but you are again referring to the facts of the previous writ application.
No, it is related to same writ application, Lordship. The same facts.
Therefore, we are saying that all those aspects, the other side had the opportunity. So the private respondent,
No, my humble submission, in this writ application, notice can be issued, Lordship. So that's my submission. Without
notice.
Lordship, kindly 2 minutes, Lordship, because I am interested for interim order.
Interim is difficult.
No, you understanding the problem. The last writ, he was there.
But now the
Mr. has come. Mr. Counsel, you can be charged of bench hunting also. That you allowed your writ application to be dismissed. And then you are raising the same plea in another writ application. So let us...
not same setup, Lordship. Not same facts. Lordship, something different. So
no, it's because of the development.
No, not development, Lordship.
All right.
What they have done, Lordship.
Mr. Dalai, with respect to the same contract or not?
Lord, same contract.
You should notice. Yes. So and so accepts notice.
Lordship, only short returnable debts, Lordship. So that's
short, yes. Short returnable. What can be shorter than 29th October?
May I
do it by tomorrow?
Lordship,
You do it by tomorrow.
Lordship, what I, Lordship, I take special private parties, can I take message, no, sorry, notice on special messenger, Lordship? To
do it.
Lordship, grateful, Lordship.
Yes.
18.
May I please, your lordship. Here this petitioner files this application for a direction to the opposite party number 5, my lord, BDO, for the fraud for allotment of fraud for allotment of Madhubhav pension beneficiary list 2024, my lord. My lord, here this Yojana has come up from 2008, my lord. And in the year 2024, those are whose person are not in this list, their list has been taken out, my lord. But who want to take this benefit, their name is not there, my lord. By doing the fake voter IDs, they have taken this scheme as a beneficiary. And on 2024, this petitioner made representation before the collector, Balesur. And after that, also a reply has been came from on the same date from District Social Security Officer Balesur, my lord, to the BDO.
Your state was going to frame some act or rules for grievance redressal.
Yes, Your Lordship. Chief Ministers.
So something is happening. Otherwise,
there's a grievance.
otherwise they find the High Court to be the best place for filing representations.
Or the Chief Minister. will
Chief
listen
Minister's
to the
He is hearing all the
grievances,
allegations
yes,
each
yes.
Monday.
Each
but
Monday.
Now he has extended to district-wise units.
No, not only that. You had a proposal. The state government was intending to either enact a law for redressal of grievances. Of any kind. So I don't know whether you have
So these
done that
things
or not.
will go
Otherwise,
directly to the High Court.
Right,
yes, did you approach them?
Take instructions.
Has been also forwarded to the video by the District Social Security Officer. The allegation.
Only District Social Security Officer.
Where is your representation?
Well, my representation is under Annex 2 series, my lord.
2,
my lord.
Series.
They also the postal receipt is there, my lord. And also the District Social Security Officer and the Sub-Collector Balesur had given the letter to the BDO to inquiry in this matter within 7 days. But still, from 19/3/2024, they are not taking any kind of action, the BDO, my
So
lord.
is it your specific allegation that voter list, they have enhanced the age for which they are getting?
My lord.
Then that voter list has to be there.
My lord, also, my lord, kindly see at page number 26, my lord, where the sub-collector has given, my lord, in this page number 26, my lord, second paragraph. In this connection, you are requested to inquire the misrepresentation of age document.
Yes, yes.
My lord.
Cancellation
So
process.
see, madam, he makes a representation
Yes, Your Lordship.
to the sub-collector. Sub-collector has forwarded the grievance to the block development officer.
Yes, Your Lordship.
Now, because block development officer also could not do anything, he has approached a lower authority by filing the writ petition.
My lord, also the
because
district
we are under block development officer. So this is how. And if any representation is filed really, and either you may reject that or entertain that. But
Let it come on 9th. Your Lordship will take instructions.
Also about that
About the
that
grievance mechanism for redressing of
redressal of the grievance, that
please
also.
do it. Otherwise we are what? We are officer in charge of a police station.
So that we
If FIR is not registered, we are block development officer of a block. If he does not listen to their grievances, we are district magistrate of a district, we are executive officers of municipal corporation.
We'll see to that. Your
This
Lordship,
is-
about
this
that mechanism.
is
of
not the way it
redressing
should
the
happen.
grievances, Your Lordship.
Copy of the letter has also gone to the collector apart from BDO.
Yes, Your Lordship.
Sub-collector has also sent a copy of that letter to the.
And see, we cannot ignore their rights to be heard at least. As requested on behalf of the opposite parties. List this matter when?
On 9th, Your
Ninth,
Lordship.
you also call ninth in the middle.
Eighth.
Eighth.
You get instructions or you'll ask them to be personally present?
No, we can obtain instruction in the matter.
Please tell your officer.
Yes, yes.
That they should frame some guidelines, something. They can, there are so many frivolous applications are received. They can say rejected or something. But if something is brought to their notice, they have duty to consider.
19.
Please, Your Lordship. This is in the nature of PIL, my lord. Lordship, see, prior to this, my lord, some petitioners have come before this honorable court in the PIL, my lord. As a construct 19. Construction, my lord, construction on the, my lord, government land, my lord. That is particularly the Jalasaya land, my lord.
Government land?
Government land, my lord. That is, Your Lordship, my lord, Annexure 6. That is the Anabadi, the government land, my lord.
Yes.
Page 29.
Yeah.
And though it is a Anabadi land and particularly the land is in the Jalasaya land, my lord, they are unauthorizedly, my lord, encroaching and constructing house.
Who?
But some persons, my lord.
Some persons means?
My lord, prior to, my lord, some, Your Lordship, may I give the photograph, my lord, that exactly, my lord, not known, my lord, who has constructed, who is constructing.
Jalasaya?
Jalasaya, my lord, Your Lordship, will go to
Do we pass on
page, yes, my lord,
agricultural
Your
land?
Lordship, page 31. 31, last but one. Last line but one. Page 31.
That is one plot.
Jalasaya, that is one plot. I'm saying about one plot. My grievance is against one plot.
That one only.
My lord, that. Because that is the Jalasaya land, my lord, and the whole, my lord, extra water, my lord, that is flowing through that, my lord. Otherwise, my lord, if it is blocked, my lord, there is a flood, my lord, in that portion area, my lord. That
So
is
how many Jalasayas are there in your vicinity?
my lord, a large patch of land, my lord, that is, my lord, 1 acre and 1 acre 84 decimal, my lord.
Yes, it will
That
also
is
come.
large
under-
land, my lord. And if your lordship will see the earlier order that I have given, my lord, that is, if your lordship will see, that is page 25.
Yes.
Earlier read petition, my lord. Earlier read petition, it was said because there are some other name was in the were there, my lord. If at all it was recorded wrongly, my lord, you go to the appropriate forum, my lord. And we had gone to the appropriate forum, my lord. And in that case, my lord, it was deleted and the new record was produced, my lord. New record was found. That is in page 29, annexure 6. That was came to a government, that was a government land, my lord. It was declared as a government land. But in spite of that, my lord, there some persons, my lord, are going to fill up that water body and the sand, my lord, and the construction is going place, my lord. You lordship may kindly see.
All right,
I've
yes.
given the photograph.
Yes.
Photograph with that is an annex.
Yes, yes.
Even representation I have given, my lord, not responded.
So we will hear public interest litigation once in a month.
Yes.
All right. So that day we'll take up only public interest litigation. That can be done. Unless something is other.
Because I think the lordship, page 27, same for the same cause of action that come before the lordship had directed them to approach the revision authorized under section 37 of the.
That is what he's saying. There are
Yes.
it has been recorded as Jalasaya.
No, Milords. Page, Milords, if your lordship, page 29.
Yes.
Date of publication of the map, Milords, it's 87.
After correction, my lord, that is noted, my lord. In the last
body.
line, that is noted. That is noted. Case number is noted. That is.
Which page?
My lord, on page 29.
And inside that body, lot of things.
RC case number 77 by 2020, my lord, that is given. That is after order passed by this honorable court, this has been done, my lord.
All right.
Page 29.
In the middle.
In middle.
Yes, sir.
Case number 7,
After correction, my lord, this has been done, my lord.
722, 7 of 2022, 77 of 2000.
All it will see on it.
My lord.
Yes, you have something at your level.
Yes.
Otherwise. Yes.
Thereafter to collector and Tahsildar, my lord.
Yes, he'll get instruct.
Yes, ma'am.
Next.
I, my lord, stop construction, my lord, because your lordship, I have given the photograph, my lord.
What are you?
I for stop construction, my lord, at this.
That will be done. That will be removed. Don't worry.
20.
Oblige, sir.
Yeah, please, lordship, my lord. This rate application pertinent to tender to supply of the diet service, my lord, to the indoor medical patient of the MKG Medical Hospital, Barampur, my lord. So petitioner has continuing supply since 2012, and when the tender floated on 28/8/2024 for the outsourcing provider service, my lord, I participated. During that process, my lord, your lordship, two corrigendum have been issued to amend the provision of tender, my lord, at annexure 3 and 4. What they did, my lord, they changed the evaluation criteria. The mark which is obtained from the evaluation criteria, 30 marks, that has been divided for 20 marks as well as 10 marks for presentation, my lord. And my grievance is in respect of the specific condition that are stipulated under the eligibility criteria. There is authority fixed that 5 crore rupees 2 consecutive years of through eligibility to be participate in the tender process. That is the minimum criteria. Minimum amount the 5 crore rupees. My grievance while filed this application, my lord, they when open the technical bid of the all the tenderers, they discussed that at that point other services apart from the diet, they will be taken into consideration. I raised the grievance before the authority and filed my representation. When they have not considered my representation, I approached this honorable by this writ application. My specific case is that, my lord, the authority has been fixed the eligibility criteria of 5 crore rupees for 3 consecutive rupees so far as the specific similar nature of work, that is the diet is concerned, my lord. It is the in wisdom they have fixed it, but it is the patient we have to supply the diet, my lord. The cooked food, foods as well as other dry foods, my lord.
Where is that requirement?
You lordship may kindly see at eligibility criteria as per 27, man. Two point plus 2.2 V, my lord. I may read it, my lord, at 20.
Yes.
V,
Where is that crore?
That the bidder applying for a medical college must have minimum average annual turnover of 5 crore rupees.
So the similar service has been changed?
No, not changed, my lord.
Then?
But they have adopted that while I filed the representation to not to consider only taken up so far as the similar diet is concerned. That has not been amended in the curriculum itself, my lord.
No, it has not been amended, but how do you know that they are going to deviate from this?
Because, my lord, I have participated in the other medical colleges, in ACB medical college, always that. And
See, because thefts are taking place in other places, therefore, on all likelihood, there shall be some theft committed in your house.
My case is not that, my lord. My specific case, my lord,
Sir, unless you can, therefore we are putting this question, how do you know that they are going to deviate?
Because in the meantime, what happened, my lord, development, my lord. The meantime, they communicated me because I am supplying till the finalization of tender. Only that you lordship may kindly see on the annexure that I enclosed in my subsequent IA, my lord. You lordship may kindly see. Annexure 9, my lord. Where they communicated that due to higher scores, one
Mr. Counsel, your clients are have liberty after the process is over.
my lord,
Why? This is not the place, this is not the stage.
because my lord, they have not supplying anything, even if I have.
You can take whatever plea. Suppose someone also in the similar service participates and he is selected, he is more efficient than.
Of course, my
That
lord,
can happen.
I have no objection. So if that similar diet has been there, my lord. My grievance is that specific that he has not been turnover of 5 crore, my lord. That is the reason.
Who doesn't have turnover of 5 crore?
That the selected candidate, my lord. That subsequently after filing my the application,
Pretending that they will do that.
well, I have repeated. In the meantime, already they have selected the person. They have not notified. Only as I am occupying the some
No, you
rooms,
have been asked to continue with the work.
my lord.
No, you are occupied what?
The three
Yes,
rooms
yes,
in the hospital for cooking the foods.
Yes.
They directed me to vacate the same because we have appointed new person. That is the reason we come to know that is why I filed a miscase for that.
Whether who has been selected?
My lord, that is
They have not published anything.
no, not probably. Even if I have sought,
Yes,
they have given in my reply to my
26.
email. You have to apply on RTI and they will not provide so far as the mark
On
you obtain.
26,
You Lordship may kindly
the
see.
final selection was made and communication was made to him to vacate the room so that it can be handed over to the new Miller's incumbent. That letter he has got and he has annexed before Lordship.
No, that
Today is 30th. So immediately he has got it and approached the Lordships. So how can he say that it has not been supplied to him, Lords?
My lord, you Lordship may kindly see. So far as this memo, they have communicated they will not provide the mark obtained by the authority, my lord.
Short facts of the case are that the petitioner is a registered firm and presently providing dietary services at which college?
Lord, MKG Medical College, Barampur.
At so and so college, Barampur. Stop. A fresh tender was floated in which he had also participated. So stop. It appears that a firm has been selected. Oh, it's a charger. So you have it. Charger. क्या लिखा है? He has also participated. So stop. The clause 2.2. Roman 5 of the tender call notice prescribed inter alia that the bidder applying for that the bidder must have minimum average annual turnover of ₹5 crore per year during the last 3 technical financial years in quote unquote similar service. So stop. The petitioner's grievance is that deviating from the said requirement, comma, such tenderers have also been considered who do not have experience of providing quote unquote similar service, that is catering services in the hospital. So stop. Next. The petitioner has approached this court only after it has received notice for vacating the space occupied by him for providing the service, catering service after completion of tender process, as the work has been awarded to someone else. So stop. We do not see any material to support the petitioner's case that the person who has been selected or those who were considered did not have the experience of providing quote unquote similar service to similar service in terms of similar service, which is one of the eligibility criteria under clause 2.2 of the tender call notice. Tender call notice is a request for proposal. RF. Stop. We do not find it in this application. This application is accordingly dismissed. Yes.
Liberty ballot to challenge the. You also all the authorized liberty bar. Ballot
21.
Liberty, Mr.
To challenge the ballot process ballot after obtaining the details. Authorized.
Selection.
Yes, ballot.
Selection, how can you challenge? We make it clear that we have not gone into the question as to whether the firm selected for the selected pursuant to RFP has in fact does in fact fulfill the eligibility criteria or not. Top, the petitioner, the petitioner shall be at liberty to question the selection of the said bidder in appropriate proceeding in accordance with law, if permissible. Yes. Okay.
21.
Yes.
I have entered my appearance.
On whose behalf?
Petitioner.
Yes.
Today?
Today, my lord, I have the receipt.
One, my lord, I am filing application for intervention. He has not included me as party, although the impugned order itself reflects my name.
Here the case is, my lord, my limited grievance is that this was traversed to this court, honorable court. This honorable court passed an order. It was assailed before the honorable apex court. Apex court directed to consider the representation of the petitioner, but now they are proceeding without considering my representation as ordered by the honorable court. They are proceeding. Therefore, I came to my lord.
Where is the order of Supreme Court?
My lord, your lordship may look at. First, your lordship may look at page 30. The order challenged before the honorable apex court. Honorable High Court's order.
No, where is the Supreme Court?
Then, my lord, page 32.
This is WPC 24059. No.
Yeah, those are earlier petitions. Recently,
Just a minute. Just. Item number?
Item 21.
21.
Yes.
now your lordship may look at, may I take my lordship to page 32.
No, where is the Supreme Court's order?
That is page 32. Order dated 26 February 2024. Lordship got it.
Yes.
Last line, my lord. Representation complaint dated 26/9/23 or earlier complaint, if any, within a period of 6 weeks. They didn't consider it. Now they are proceeding with the matter through annexure 10. That I am assailing in this writ application. Page 36, annexure 10. Earlier it was Tahsildar by act of amendment. Now the mining officer is authorized under law.
Another SLP? Before
That was beforehand, approaching before the High Court. That was passed. Page 28, that your lordship will find that representation. 26/9/2023. At annexure 6. So my limited prayer before my lord, let them deal with and then proceed.
Yes, state.
I'll seek instructions, Your Lordship.
Tahsildar, which place?
Tahsildar of each of the place.
The Tahsildar has not been made a party here, Your Lordship.
Now the mining officer. Tahsildar's
Here, the Tahsildar has not been made a party.
mining officer is a party.
No representation is pending with the mining officer. Throughout his case is before the Tahsildar.
Now the act has amended.
This is Tahsildar. This is the mining officer which is written to the deputy
See,
director.
we have 2 years, of course 4. And if you 3 of you start speaking together, then it may become difficult for us to understand anything. So let me see where is the order of the Supreme Court that the second order.
Page 30.
Page 32.
Is which Tahsildar of which area?
Cuttack.
Cuttack.
Now, my lord, mining officer, Tahsildar has nothing to do. The action will be taken at the end of the mining officer.
But why are you referring to the Supreme Court's decision?
No, now they are not touching this representation. Eligibility was challenged before the court.
Mr. Counsel, are you relying on Supreme Court's order?
My lord.
Supreme Court's order refers to some representation to be decided by Tahsildar.
My lord, that is also I annexed. Page 28.
That cannot be seen by him. Tahsildar, according to you, Tahsildar has no role to play.
Then I shall submit it before the mining of. I have submitted it in time.
All right. Submit your representation.
Lordship may.
That I will not do.
And he is proceeding, my lord. I am within 6 weeks.
You could have seen. According to you, Tahsildar has no jurisdiction. According to you, mining officer has the jurisdiction.
At the relevant point time, my lord, Tahsildar has the jurisdiction.
Now what can be done?
Now by change of the statutory provision.
Approach mining officer.
My lord, the litigants having no fault. He has given the to right person.
See, the litigants are not at fault. We are also not at fault.
My lord, I am not saying that, my lord. I cannot say that.
You can say if we are, but who is to be blamed? Tahsildar cannot also be blamed because he has no jurisdiction according to you.
My lord, statutory
mining officer cannot be blamed because you have not approached him.
Statutory amendment has come. Therefore,
you cannot be blamed because you have.
In view of the statutory amendment, your lordship may grant me liberty to approach him. in view of the statutory amendment, Lordship,
What will you do?
I will manning officer directly and he let him consider it within a.
You may do, but we will not.
Well, I can do, but so far, if I will not take an order from my lord, that will be lying, only I am giving that, they will not comply it.
This order that your representations shall be disposed of, that will not do.
That
You approach, will give you liberty.
But your lordship may grant me liberty so that.
Hearing on behalf of the petitioner has submitted that though the Supreme Court by order dated 26/2/2024 has required the Tahsildar Cuttack to dispose of petitioner's representation dated 26/9/2023 relating to
Relate to eligibility of the auction holder so far the Soirat is concerned.
concerning eligibility of the Sairat holder, Sairat of.
Sir, that Soirat's
Which
name is
Which Sairat? First of in
Pratap Nagari, Kuakhai River Sandbed.
the changed circumstance, Tahsildar has no jurisdiction to consider his representation. So he submits that he may be granted liberty to approach the district mining officer. District mining officer raising his grievance of this application stands disposed of with the requested liberty. Yes.
Within a week, that may be dealt
Yes.
promptly. That will be my last submission before my lord. I will submit it within a week.
Do it, do it.
Short span.
Do it, huh? What? Yes.
22.
May I repeat my prayer?
See, if you file a representation, even then we would like their response.
Yes.
Now here you have not filed a representation. You are going to file a representation and you want an order from this court for disposal of it. That is simply impossible. Do it and later we will see.
Within a week, that may be disposed of within 1 month or two.
That I don't believe either. I decide matters or.
I know I am sitting here throughout the day. But your lordship may grant me that liberty or
That liberty I have given. That liberty. And I have asked them. Now henceforth, if the representations are filed without any order from this court, they will have to dispose of. No order is required.
Within 2 weeks, 1 month.
Do it. It will automatically happen. If
Again,
required, we shall lay down some guideline for disposal of representations also. So instead of passing various orders, we shall pass one order for disposal of representation.
Again, I have to come to my lord.
No.
22. In this case, the petitioner is challenging the entire tender process of opposite part number 2 for NXC Panjanagar, Panjam district miner. And where his bid has been, though he has been selected as L1 during the financial bid, but has been rejected on the ground that he has not furnished the power of attorney in proper format. He has single proprietorship, man. And for that reason, he has signed in the tender papers, man. And there is no other members in his farm to whom he will provide power of attorney, man. And for that reason, upon query or the letter has been received on page 61, my lord.
Where is the rejection?
Where
is the rejection?
Page 61, my lord. Page 61 of the writ application, my lord. Annexure 1 series, my lord. Page 61. Where it has been.
Problem meaning separate annexure 1 series everything.
Submitted the tender papers.
The petitioner, man. Petitioner himself, man.
What is this? Mr. Samantra, have you seen?
I have seen.
Do you have a name of your firm? You have. That
No,
creates
ma'am.
confusion.
Has been registered in his name, ma'am.
His name.
His name, ma'am. I have also inquired, madam,
Page 60.
before filing of the rate application. That's what I
Page
said.
60, it says Surendra Bari, contractor and supplier.
No, they are saying if anybody.
How can
signs the
see?
bid on behalf of the bidder, if he has signed, then what is the power of attorney?
No, yes, that should be there. No.
A 1 week time is allowed for the-
NSC.
for the for opposite party number.
Opposite party number 2, ma'am.
Who is that?
Opposite party was issued the tender notice, ma'am.
Who is he?
My lord, the executive officer, notified area council.
Who will appear for notified area?
Madam?
Who will appear?
Bhanjanagar, any council? Do they have any specific council engaged by them? They'll have to take notice.
No, government will look after, I think.
No. It's a
So legal document may issue notice.
notice has to go. We can
Notice to
appear.
go.
Issue notice. 1 week, 6 weeks. The petitioner shall be at liberty to make a mention for urgent hearing after service of notice.
And I may be, may opposite party number 2 kindly be restricted from handing the position to the tender holder, my lord. Though, for that, otherwise you will handing over the charge to the tender holder, the, or who is the.
He has to be made a party, if the successful bidder has to be made a party.
The maximum party. will
Further
be-
proceeding may kindly be restricted till the appearance next date. I will,
Someone has been selected.
someone has selected my last.
So you have not implemented party.
I have no instruction. I have got.
Then you don't have any instruction, then you suffer. Yes, next.
23.
I may plead on. The case of the petitioner here before Lordship is assailed the impugned order dated 13/8/2024 passed by the Chief Development Officer, CDO, Executive Officer, Jilla Parishad Mayurbhanj, inter alia, cancelling the offer letter for execution of agreement for implementation of LED street light system on turnkey basis in the district of Mayurbhanj. Admittedly, my lord, in the month of March, I was selected, my lord, and letter was issued on 15/3/2024 for come and make the agreement. My lord, again, the authority issued on 1/7/2024. My lord, then on 4/7/2025, the petitioner intimated that he is ill and admitted in the hospital and otherwise also and asked for time for 20 days. Then, my lord, on 24/2024, the petitioner intimated a letter again seeking 15 days time. On 1/8/2024, the petitioner asked for extension of time till 22/8/2024 to complete this agreement through email, and on 13/8/2024, let's see, can it turn to page.
So are you well now?
My lord, now they have cancelled my agreement.
So after cancellation, he has
I
recovered.
have approached the collector also for that purposes.
Yes.
My lord, kindly
You
see.
cannot do it. Why are you unnecessarily allow someone else to do?
No,
You
no.
cannot execute.
How
But
many
I have also,
extensions? How many extensions did you ask for?
no, my contention before Lordship is twofold.
You did not ask.
My
for any
extension was never rejected, nor any show cause was issued. Guideline says agreement has to be made within a period of 15 days.
Provided you are willing.
My lord, from March till July, they waited. And they have not cancelled my extension. I can understand they cancel my extension or giving me an opportunity so cause why it will not be cancelled. This is my contention. And thereby I have approached the collector also. That is pending before the collector. And it, as on date, my instruction is it has not given to anyone. But they have said now they will call L2, L3 and L4 edition in the impugned order. So I have already ventilated my grievance before the higher authority collector, my lord. And in other districts also agreement are still going on because I have succeeded in 4 districts. Mayurbhanj is one of them.
All right, we will pass on this. Third. List of orders after holidays. Yes, next.
24.
All right.
A plus lordships. Item 24, Manas. Please, lordships. Manas, these are batch of 4 petitions, Manas. Manas, we are impugning the tender document, which is on page 261 to 267. But before that, I will take your lordships, Manas, to page 244, which is the government order regarding the MSME tenders. And may I take your lordships to page 244, which is the government order of 23rd of March 2012. And I'm reading paragraph 3, Manos. This is a central government order. There is a central government ministry department.
Just a minute.
Please, lordships.
244.
It is the central government order of 23rd March 2012.
Annexure.
Annexure, Manos, this Annexure 5,
Part of Annexure 5.
page 30 to 260.
Yes.
So those are the copy of the MIL store purchase.
MIL store purchase manual.
And
But
copy of the procurement policy.
yes, Manos, that's the first 244 is the procurement policy for Ministry of Micro, Small, Medium Enterprises.
You want us to see which page?
244, Manos,
The order,
order.
procurement policy order.
Public procurement policy for micro and small enterprises, order 2012.
Yes.
These are lordships. Whereas the central government ministries, departments and public sector undertakings shall procure minimum of 20% of their annual value of goods and services from micro and small enterprises. I'm referring to Manoj's paragraph 3 now, under and whereas the public procurement policy shall apply to, the paragraph 2 is public procurement policy shall apply to micro and small enterprises registered with the district of Khadi and village industries, etc., etc. But I'm not referring to, and do not come to, or to micro or specified by Ministry of Micro and Small Medium Enterprise. And coming to paragraph 3, whereas the public procurement policy rests upon the core principle of competitiveness, adhering to strong procurement practices and execution of orders for supply of goods or services in accordance with the system which is fair, equitable, transparent, competitive, and cost-effective. May I take a lordship directly to the impugned tender, which is on page 267.
Yes.
And I'm referring to Manas a particular policy. May I show Manas in this particular tender itself? I'm referring to a particular policy which is a special clause introduced for the first time on page 271. Manas, 270 specifically clause 38. A special note has been introduced. Lots of chance that, Manas, page 270, clause 38, and the note which is in bold, Manas.
$271, which one?
270, Manas.
270.
Yes, please, your lordship. Just before that, because 270 and 2 carries on to 271.
Yes.
Clause 38 and the bold note, my lords. The bid is SDOTE, restricted for MSME firms having manufacturing facility within the district of.
No, you are reading which clause?
I'm reading clause 38.
Note to,
38.
Yes, note to the clause 38. Please, your lordships.
Yes.
This bid is SDOTE, restricted for MSME firms having manufacturing facility within the district of Belangir, Odisha. Established firms are not eligible to participate.
Yes.
And then I take a lordships to clause 40, which are special conditions for SDOTE case. The firm should have adequate manufacturing facilities
of the above items within the district of Balangir, Odisha. And the general manager, ordnance factory, reserves right to carry out the capacity verification of any firm participating in this tender entity. Now, for the first time in a tender document, one of these special conditions have been imposed restricting or limiting procurement only from a particular district and eliminating all manufacturers from all over India who have been participating in the tender process with this particular ordnance factory in the past. Manas, we are such group petitioners, Manas. We have been participating in the tender process in the past. We have been disqualified only because we do not have a manufacturing facility in the district of Balangir, Odisha. Now, this restricts only to two particular manufacturers who have been selected. May I take your lordships through that selection process also? They have been selected, my lords. And one of those manufacturers has been disqualified in the past only for supply reasons. He has a poor supply for.
No, you are challenging this special condition?
Yes, please, your lordships.
Let us have their views.
Because this is a violation of Article 14, Manas, in my humble submission.
Maybe according to you, violation of Article 14.
What is the last
But at the same time, in order to ensure,
please,
that there is proper development in the district and even progress in all the districts throughout,
please,
such conditions can be met.
Correct. Your lordships rightly observed even progress in all districts. Now, why to select only Balangir district? They could have selected people from other districts too. I humbly bow down to that observation.
No, because the firms should be there in Balangir. This is for Balangir. This must be for Balangir only.
No. What I'm saying, Malos, is humbly submitting, Malos. Now, what is happening is this tender is floated by the Ministry of Defence, Government of India. Now, Government of India, I showed you lordships on page 44, has a policy in place which says that bids have to be competitive, fair, equitable, just, and everything. Now, in this particular case, MSME bids have been invited. We are also an MSME enterprise. We have been excluded from this particular tender document only because we do not have a manufacturing facility in the district of Balangir.
You can establish on.
No, here is what I submit, Manos. There is a proper procedure in place to become an established firm, even if your lordship select. Now let's come back to that particular clause of page 38.
So similar provision must be there for other districts also.
No, Manos, in fact, this is the first time such a clause has been imposed, and only for a district procurement for district of Balangir. May I humbly submit, Manos?
Where is your manufacturing unit?
We are based out of Yamunanagar in Haryana, Kanpur. And we have been participating in the past also, Malos. And we have been completely excluded from this tender process. More so, what I want to submit, Malos, humbly is if your lordship wants to see the tender document, there is a very big contradiction. I want to take your lordships to page 267. Lordships know that. And Malos, in this case, what is happening is, lordships may kindly see page 267.1, subclause 3. What is happening is that
is the tender process over?
Malos, the tender process is over. We have been disqualified. We have been disqualified only because we do not have a manufacturing facility. Now, what is happening is the persons who have been selected have not supplied even a single quantity of good to this under this tender. Manas, they were supposed to supply, they have not supplied at all. What is happening rather is the person who has been selected has a poor supply performance in the past. That has been recorded by this particular ordnance factory, and he has been selected now. So it seems that there is a complete case of chaos and contradiction. What I also want to mention, lordships, is if you also see page 267, only 20% can be procured under this policy. They themselves have contradicted the tender document by asking for 50% under this policy. So therefore, there are many defects which in the tender itself. Now, on one hand, we have been disqualified because we do not have a manufacturing facility. On the second hand, now tender is being floated for 50% procurement under this policy, whereas under the Government of India, only 20% can be procured under this. So what is happening is, my lords, is that they are violating their own guidelines, and Ministry of Defence, in other words, is being...
All right, let them file their affidavit. There must be some purpose.
This for 1 and 2 we are appearing.
You are coming from Haryana.
And UP
people in Balangir. And it requires that one should have manufacturing unit in Balangir.
No, correct. There may be the policy behind this must be a noble policy.
Right.
Correct, Manos. So I bow down to that observation that it's a noble policy for promoting district of Balangir, manufacturers of district of Balangir. I understand that, Manos.
Not only manufacturers of district of Balangir. They said you should have manufacturing unit.
Correct, so that
they
they can
want
promote, they can
employment.
promote Bravangi district. I understand that. At this one, it looks very good on fair on paper, my lords. I don't object to this policy at all. But now here is a contradiction. What is happening is that if your lordship was to see a person who has been selected in the tender has been blacklisted by the same ordinance factory.
You cannot blame that. A person, because he has, he may not be as competent. He may not be as sound. He may not be as proficient as you are. But because he has a manufacturing unit.
Yes.
At Bolangir.
And they want to give work to that manufacturing unit. Sure enough. Sure enough.
We compromise.
My lords.
Compromise with the efficiency for development of a reason or development of a person or.
My lords, no. So now here is my humble submission, my lords, is. Here what it is that they're contradicting. Lordship saw that page 244, which I showed to your lordship. Let's come back to 244 again. And what it says 244 is that whereas the public procurement policy rests upon the pure principle of competitiveness, adhering to the sound procurement practices and execution of orders of supply of goods and services in accordance with system which is fair, equitable, transparent, competitive, and cost effective. So if it is competitive, then equitable, correct, and competitive. So it doesn't say that it has to promote one person or an individual or a factory.
There is no question of person.
Because competitiveness.
You are from Haryana.
Yes, I'm from Kanpur.
You may be from Kanpur.
We are a group of petitioners.
Yes, you may establish a manufacturing unit at Bolangir.
So then, no. What I'm submitting, Malos, is so in this defense procurement policy, what happens is to set up a manufacturing facility, and they have also excluded established manufacturers. Lordship may kindly see the policy. Lordship saw that on page 271. Let's see 267.
All right, let them file affidavit, we will see.
Please, your Lordship. In the meantime, we submit Malos because.
My lord, I'm just adding these things. It is earlier this ordnance factory floated this as one of the concern for the Ministry of Defence. Now the emulation is met. And the name has been changed. That's why let's may come to the page 40, chapter 1 of this tender document. It is specifically written the maintaining and uninterrupted and reliable materials of the required quality is a increasable necessity for shameless and manufacturing munitions India Limited. This is a government organization of the Ministry of Defence. It was provided. And they have come with a new policy for the protection of ministry, defense articles. Earlier, the policy has been taken care of, it has been gone, and they have coming with a new scheme, new policy, and new method. That's why this policy might have given because I don't have an instruction. What I understand, my lord, this government of India has floated this tender for the protection of the ministry, which is procuring the explosive ammunitions. All these things are very specific in nature. Right. It is not an ordinary tender. Munition India, they have made a party. They have made a ordnance factory. Depending on the Munition India, they have made party.
On behalf of OP number 2 only.
No, my lord, I am for OP number 1 and 2. But this my friend is required to mention the Munition India party because after the emulation, the
tender has been
not now. Let me see. Let us see.
Yes.
The stand of let us understand the policy.
Yes. Yes, my lord. No, yes.
Kindly see for a minute.
In a tender document itself, it was explained by the government of India.
44 lordships. May I just have that?
No. I am on the introductory chapter. The challenges and the procurement. That is in chapter 1. That's why I am telling you. Otherwise, issue notice. I will file the details counter thereafter.
You notice to only OP number 1 and 2.
Yes.
That counter so receives notice. So please this 4 weeks for the counter affidavits to be filed on behalf of said opposite parties. Yes.
Number 3 and 4, the private opposite parties. Manner is confirmed with OP number 1 and 2 only.
1 and 2 only.
May I request
fine.
To review page 344A, humbly submitted, Malots, that the person in whose favor the tender has been granted, 344A, I will just read that, has been disqualified for opening bid since the firm has poor supply performance against articles.
So what do you want? How does that help you?
How it helps me is, Malos, that lots of rightly observed that the policy has to promote the district of Balangir and manufacturers and manufacturing in that district. Now, a particular person who has been selected has had a poor performance record with this particular ordnance factory itself. So, and they have been selected in this, only 2 people have been selected. Rest everybody has been disqualified either for not having a facility or not participating, and because of this condition. And so therefore, what I'm humbly submitting is that this will set a bad precedent, because your lordships is actually reviewing the policy. Lordships is reviewing the policy, examining the policy closely with the counter affidavit of the government also. I bow down to that observation. What I'm submitting is that because your lordship, so that a similar tender will be floated after October.
We don't know. We don't know. They can approve. We can't foresee what will happen in future, and if something happens in future, how will we react?
Please.
After that. So,
but in the meantime, procurement under this tender, because no supply has been made. My humble submission and request to your lordships is that in the meantime, because we are seeing that the policy is bad, the tender document is bad because of defective procurement requirements, because they are asking for 50%, only 20% can be asked for. May stay the process of the tender.
No, my lord. That part ka tha.
Yes.
Notice in the interim application also. Please, your lordships.
Yes.
25.
May I please, your lordship? The petitioners belong to SC community, my lord, and applied for having come across a advertisement, applied for tender, my lord, and his tender evaluation committee selected his technical evaluation committee selected.
This is item number 4.
Yes.
So 24.
25, my lord.
25. Sorry, 25.
Yes, ma'am.
Plastic transport.
Transportation of LPG cylinder from ex-Khorda to its
Yes.
very, very much.
So what happened?
What happened, my lord? My tender has been admitted. I have been awarded with the tender, my lord.
Yes.
The fact remains in this case, my lord. Earlier, the IOCL has been granted some relaxation for SC community, my lord. Those persons are applying and belong to SC community. In security deposit, there is some relaxation is there, my lord. But in this tender, they have waived that, my lord. I have annexed, and by annexure 6, I have given the comparison of the IOCL, my lord. If you lords to turn to annexure 6 as page 13 from page 27, my lord.
So do you have any right of such relaxation?
Yes, my lord. As because the same IOCL company has given relaxation so far it relates to transportation of the petroleum products, my lord. So far it relates to LPG cylinder, my
Do
lord.
you have any right? Is their policy? So which law has been violated? See, we can interfere only if you are in a position to demonstrate that one of your legal rights has been violated, constitutional rights has been violated, or you can demonstrate that their act is illegal. So how is that their act violates which provision?
Discrimination part is there, man.
Discrimination
So far it relates
See,
to
all the persons have been treated equally.
equally, man. I have admitted my tender is in my
All
favor, my
the
lord.
members of the scheduled caste have been treated equally.
Yes, my lord. They have so if your lordships turn to page annexure 6 series, we start from for a moment, my lord. We
Yes,
start
yes.
from page 27, my lord. Indian Oil Corporation. If your lord turn to page 29
Yes.
in 29 starts with security deposit, my lord. Relevant portion is page 30, my lord. 30. The security deposit column number A, my lord. Security deposit shall be rupees 8 lakhs for contract for general tenderers, including MSC generals. The second, my lord. For SC/ST tenderer, including MSC/ST tenderer, also up to RO dealer, so and so, the security deposit shall be rupees 50,000 per contract, my lord. This is in respect of another, my lord.
That is not the law. 30 is not the law. 30 is a clause.
So also in case of Bharat Petroleum and HPCL, both
both the petroleum organization, all of the petroleum organizations granted relaxation so far it relates to belong to a particular community, that is SC/ST minor.
No, we cannot. Because the present writ application has been filed in the name of Mrs. Swastik Transport through its proprietor SMT Subarna City. So according to the petitioner is aggrieved by the action of respondent Indian Oil Corporation in not providing relaxation in payment of security deposit towards transportation. What is this transportation?
Transportation of Indian LPG
transportation of
cylinders.
Indian
The
let's
tender.
be cylinder in vertical position on unit rate basis from X Khorda LPG bottling plant. The petitioner petitioner claims to be a person belonging to scheduled caste. Tabu agreed. So next, learned counsel appearing on behalf of the petitioner has drawn the court's attention to various other tender notices brought on record by way of annexures wherein the requirement of security deposit was relaxed to a great extent. So stop. He has submitted that similar privilege ought to have been extended in the present tender process also. So stop. Next, learn counsel for the petitioner has, however, not been able to draw our attention to any statutory provision or binding decision of the IOCL which provides for grant of relaxation to the members of scheduled caste, scheduled tribe candidate, scheduled caste tenderers. Full stop. Learned counsel appearing on behalf of the petitioner has also submitted that non-relaxation is arbitrary and discriminatory. Full stop. We do not find any force in the said submission as the said policy has been made applicable to all members of to all persons belonging to scheduled caste category. First off, next, we do not find any merit in this writ application, as we do not see any illegality in the impugned tender provision. First off, the writ application is accordingly dismissed. Stop. We make it clear that any observation made in the written order shall not preclude the IOCL from taking any decision by granting relaxation as has been done, as have been done in other cases. Yes.
In similar case, my lord, your lordships has issued notice on few days back, my lord. And that apartment today is the last date for submission of security deposit, my lord. 38 is the last date.
Cannot
As
be
per
done.
Annexure 5 series, my lord. Today is the last date, my lord.
That I have decided. We cannot just observe that IOCL may relax. We cannot.
Today's 30th is the last date.
Nothing can be done, sir.
Item number 40.
May I pray one thing? A relaxation may be given so far as 30th. Today is the last date, my lord. As because I am prepared to suitable today, and today is the last date. Now it's already nearer to 4 p.m. and the lordship may grant some time to deposit.
Yes.
May please your lordship. May please your lordship. This is a PIL matter. Matter relates to Sisu Home, my lord. This matter appears today's lease as per order dated 26 September 2024, my lord. As this honorable court in course of hearing on 26 September 2023 desire clarification on the following matters, my lord. That is date on which
Which
the
item is this?
formalities
40.
40, man. This matter appears today's release as per the
Just a minute.
my lord.
In fact, we have been arguing on your behalf.
My lord. On behalf of Maitri
So
Sanstha.
you may not be required to make your submissions. Let us see.
Yes, lordship's last occasion asked me to obtain specific instruction within what time this new building will be ready for use. I've talked to them. Lordship suggested 6 weeks. In fact, the record alienation proceeding will be over. It's at the stage of RR will be published and lease deed will executed within a period of 3 weeks. All this process. And thereafter, the building plan, it will take about 2 to 3 weeks for approval of the building plan. And thereafter 2 weeks for this fire safety. So altogether only 8 weeks will be required for getting this building ready for use.
Can you
Yes,
give it on a chit?
Yes.
People.
Agenda.
नहीं वो दूसरी same.
I draw lots of kind intention, one para, small para, madam. On 14/12/2021, or they stated, only para 34, let's say kindly see. Madam, 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 madam.
By what time he the still duly constructed building of whensoever fees shall be put to full use.
Yes.
This form. Correction which he has received, he has submitted that it will take 3 weeks for completing the elimination proceeding and publication of reports of rights and execution of these deeds in favor of the superintendent city government. The formality of approval of building plan shall be completed within 2 weeks. So, 3 weeks further time can be required for getting the fire safety certificate from fire safety authorities. Oh. Next. The construction of new building, new building had started.
2019.
Already completed. Civil work has already been
2019.
completed.
It will be completed by 24 months, as the report says. It will be completed within 24 months in 2019.
We are totally surprised that till date litigation proceeding application of for record of right and execution of lease deed have not been completed. Stop. Be that as it may, this is on deed B. Before will appreciate taking the lead by what is required to be done and about what are the things which are required to be done as noted above. Most of them being formal in nature, are completed. Process of lifting will begin thereafter.
Yes, no, not shifting, install, because nothing will be shifted. Old building will be there. Only installation of new machineries and OT things will be there. No shifting will be required.
May I submit, my lord? The medical instrument as yet not been procured nor has been installed. How that will, how the building will be functional? That is their letter, my lord, by the annexure B, my lord. That has been placed.
It will be procured by the government.
That process is not.
Because pending before the.
That affidavit I had stated that by March to end of March 2025, this will be done. Procurement of medical. In my affidavit, I have stated earlier affidavit.
I submit. Work started in February 2019, as mentioned. And for completion of the work, the contract period was for 24 months, but time has been extended from time to time up to 31st December 2021. I just mentioned Lordship's query. I said that 2019, that is the specific month I am clarifying before your Lordship.
I may be permitted to draw your lordship kind and small submission I want to make. Annexure C of their affidavit, my lord. They now, there is a waterlogging process already been started. Only because the building which has been newly constructed, my lord, the plinth is very low, my lord. For that reason, rainwater is flowing to the new building. For that reason, my lord, I want to draw your lordship a kind attention to Annexure C, my lord. That is the letter communicated by the superintendent to the DMT, my lord, wherein he said, only 2 minutes I will place the facts that have been stated, that the existing internal drainage system is not adequate to clear the rainwater from campus. In addition to, you face lot of difficulties, occasional rainwater to the, it needs renovated. For that reason, they require 8 crores rupees, my lord. That is their request, my lord. That is Annexure C. So my only submission before your lordship, if this amount will be sanctioned, then only the waterlogging problem can be solved to some extent. But the plinth is very low. This problem will continue. For that reason, we have inspected through a technical person, and we have also submitted that before the government, and also the copy of which has been filed before this honorable court, my lord. So there will be a very big problem, and 8 crores rupees has been demanded.
11/7/2024, just now.
Yes.
My lord.
My lord.
This letter has been now written by the superintendent on 29th of August, Lord. That will sort out, Lord. It's an internal problem because it has got nothing to do with the building.
My lord. My lord.
Address to
Address to DMT, Director of Medical Education and Training, Odisha. Odisha. Dated 29 August 2024.
Going on.
my lord. All right.
The date may be fixed so that I can intimate him to 29th November. November. Yes, we say working day.
Second of December. Yes, yes, no. Regarding waterlogging also, by that time they will give reply.
Simultaneously, so that. it
Yes,
doesn't
ma'am.
arise in
Because
future.
the 8 crore has
Meanwhile.
been demanded by the municipal corporation for this.
Drainage, okay.
Drainage bank.
Meanwhile,
For drainage municipal corporation.
Direct all the authority. Ensure that
my lord.
effectively resolved by in place adequate drainage.
Yes,
Oblige, my lord.
41.
Yes.
Item number 41.
Yes. ଆପଣଙ୍କର ନାଁଟା କ'ଣ?
Revelation of answer. Nana Chakradhar Sahu.
चक्रधर साहू.
Yes, sir.
Very near.
Sir, मैंने लक्ष्य के आना था.
Very close to my name. All right. Yes.
Sir, I have attended an examination, competitive examination, where my boss has been failed me.
You appeared in competitive examination.
When, Mr. Sahu, when? Quebec.
2008.
2008 you appeared in competitive examination.
2009 to continue करता है वो जो केस है. अब तो मैं तो इसको फाइनल कर दीजिए और जो होगा होगा.
That we will.
Notice.
I am expressed my views in this paper.
What is your age?
My age is 70. Age October 5 को 70 complete हो जाएगा.
क्या चाहते हैं आप?
एग्जामिनेशन तो मैं चाहता हूँ वो रिजल्ट जो होगा मतलब एग्जामिनेशन में जो पेपर हुआ ना तो री एग्जामिनेशन का इवैल्यूएशन करके लिए.
कौन सा एग्जामिनेशन?
जैसे कॉम्पिटिटिव एग्जामिनेशन था वो जो अकाउंट्स एग्जामिनेशन कॉम्पिटिटिव एग्जामिनेशन.
आप अपीयर किए उसमें?
सर मैं रिटायर कर रहा हूँ. मैं 2013 से रिटायर कर रहा हूँ.
इसलिए तो पूछ रहे हैं अब क्या होगा.
सर तो क्लोज हो जाएगा.
और एक there is another problem. You have impleted
केस क्लोज होने का बहुत तरीका है. केस क्लोज होने का अगर केस क्लोज होना चाहते हैं तो केस क्लोज तो ऐसे ही हो जाएगा. आप चाहेंगे केस क्लोज कर.
सर at the time of review petition on the honorable court at the time of मैं लिखा हूँ इसे लिखा हूँ.
So you are challenging the order where
yes, sir.
It has been disposed of as withdrawn. Order disposed of as withdrawn. Respondent number 2 is included in person and the writ appeal notice is not sufficient.
My lords, may permit, I will appraise the lordship.
तो आपने इस ऑर्डर को चैलेंज किया.
Yes, sir.
जो
ऑर्डर हो तो खारिज हो गया
मैं जो रिवैल्यूएशन के अप्लाई कर दिया वो अभी तक डिसाइड हुआ नहीं।
आप कानून ऐसे समझ लें, फिर अगर बोलेंगे तो आपकी बात सुनेंगे हम लोग। ये ऑर्डर था, ये केस आपने विड्रॉ कर लिया हाई कोर्ट में, रिट पिटीशन आपने विड्रॉ कर लिया, रिट पिटीशन वापस ले लिया।
नहीं सर, मुझे बाध्य किया है और मैं ऑर्डर नहीं चाहता हूँ और जज साहब कहेगा ऑर्डर दस्तखत करो ना पेनल्टी लगेगा, मुझे पेनल्टी लगाओ मैं केस चालू करो। तो जज साहब ना वो सुना नहीं, वो एक तो एडवोकेट को बोला वो उसके लिए एप्लीकेशन लिखा दो, वो दस्तखत कर देंगे। मैं इसका बाद मैं रिट अपील किया।
रिव्यू किया?
रिट अपील
नहीं, वो विड्रॉल जो हुआ उसका रिव्यू फाइल, हैव यू फाइल्ड अ रिव्यू? उसको रिव्यू फाइल किया था वो जो विड्रॉल ऑर्डर को सिंगल जज के सामने?
नहीं
मुश्किल है, थोड़ा दिक्कत है हम लोगों को।
क्या
आप क्योंकि आपने विड्रॉ कर लिया तो अब हम उस ऑर्डर को गलत नहीं बोल सकते हैं।
हाँ, मैं चैलेंज किया उस ऑर्डर को, चैलेंज करके और रिट अपील किया। रिट अपील 1737 of 2022.
Yes.
My lord, the fact is that the entire issue has been decided in another writ petition that was preferred by the petitioner in 2008. In all the forums, he has lost. I am just submitting 2 copies, my lord, lordship. Just appraise the lordship.
Date chart will run into 10 pages.
Only 3 orders of the honorable court. Lord, first is WPC 8091 of 2009.
But everything stems
Same
from,
issue, my lord.
no, everything stems from that problem that he did not pass that exam, accounts exam.
My lord, he failed, my lord, in English
so
paper 1.
That is the
So he
issue.
was not selected. My lord, that was entirely decided all the issues and it was dismissed. Thereafter, he filed review petition, my lord, in 241 of 2017. That has been dismissed by order dated 4/4/2018. I have just submitted.
अच्छा, इसका सुनवाई करके वो दे देंगे और फैसला दे देंगे इसका। फैसला इसका दे देंगे, आपकी सुनवाई कर लिया हमने, फैसला दे देंगे। 2 या 3 पेज में देंगे, ज्यादा नहीं। ठीक है?
ठीक है।
8 so for orders after did no speak about 20
Series 10 who has you?
I don't know, 42.
Right. Item number 42, my lord. We are here with challenging annexure 5 at page 171, your lordship. My lord, here we were challenging on the ground that no show cause notice, no opportunity of hearing, or no documents was given, my lord.
Where is the order?
My lord, at page 171 of your lordship's brief, my lord, page 5, annexure 5.
During pendency, they issued a notice.
My lord, this was done. My lord, what has happened while this was pending, the next year, they gave another set of leases. They gave a show cause notice and a demand. Those, my lord, have been dismissed also by a coordinate bench of this honorable court. My lord, I'll just hand over the copy. I've given the copy to the. There, my lord, it was also dismissed that although show cause notice has been given, the documents have not been provided. So, my lord, the order that your lordships are holding there, a show cause notice was given. Despite that, it was rejected, saying that the documents have not been given. In my case, my lord, no documents, no show cause notice, nothing. I've just given 2 orders of 2 coordinate benches, my lord. Similar cases, my lord, where...
So you are challenging annexure 5?
Yes, your lordship. This annexure 5 is 12 August 2022. wherein my lease period itself expired on 11/5/2022. So 3 months after my lease period got over, they gave me a demand without any show cause, without any documents, without the proof of what scientific assessment have been done. And now, my lord, while this is pending, they have initiated a certificate proceeding, my lord.
So certificate proceeding, you can take any plea, every plea.
My lord, that
The
they are,
plea which you are taking here, you can take there.
my lord, they are denying it. My lord, what has happened, my lord, why my predicament is, my lord, similar rates have been dismissed. So, my lord, in the certificate proceeding, my lord, it's a batch of certificate proceeding. So, whichever has been dismissed by your lordship, they are allowing it. They are removing it. But which are there, they are continuing with it, my lord. That's my entire predicament.
No, we couldn't understand.
My lord, what has happened? My lord, there was a batch of matters, my lord. And so certificate proceeding has also been initiated in batch of matters. So, my lord, on the second day, a lot of people appeared for all the batch of matters. In all those matters where your lordships in different orders have been pleased to pass similar orders, wherein they have quashed it and sent it back for rehearing, that they are dropping the certificate proceedings. But here, my lord, when we said that these are pending, they said that we will not hear it because, there is no interim or there is no stay or there is no quashing. So, my lord, that is why I'm.
There is no quashing. Where is the question of why should we quash?
My lord, in this, my lord may see, my lord, in the coordinate benches, what they have done is on the ground that my lord may kindly see. The first order, my lord, of 1/6/2023, which has been referred into 22/6. There, my lord, may kindly see. Page number 3, last paragraph, may I state, my lord, and I quote, considering the above submissions of the learned counsel for the parties, this court is satisfied that the impugned demand notice cannot be sustained for want of adherence to the principle of natural justice. This court therefore sets aside the order of demand dated this and directs that if this document sought for by the petitioner is supplied to the petitioner as undertaken, the petitioner shall file a detailed show cause reply to the opposite part number 3 within a period of 2 weeks from the date of receipt of the documents, and on filing the.
Where is the requirement of notice?
There is no legal, there is no statutory requirement, my lord. But because this has been done, this has been done.
This has been done.
My lord, this has been done, my lord, after my period of lease is over. My lord, on 11/5/2022, my period was over. Now, 3 months after that, they gave me a demand. My lord, may kindly have a look at the demand itself, Annexure 5.
No, whether this demand has been issued under which provision of.
Okay,
whether that requires.
For extraction beyond the limit.
My lord.
For that they are saying we had gone for a field inquiry and that we found.
My lord, in fact, they are not even saying, they are saying a scientific, yes, scientific assessment has been done.
Under which provision you answer?
My lord.
No, if they have the power, they will do it.
Yes, Ms. Patnaik, demand under which provision?
46, there is an alternative remedy, your lordship, they can go on appeal in 46. And the order of the
Demand is under which provision? Mining laws.
Odisha Minor Minerals Concession Rules, my lord, 2016.
What out?
Which one? Because there are so many changes.
The law of mines.
No, but why to 46 you will not invoke?
My lord, your lordships are correct. My lord, on 46 I can appeal, but my lord, here they have not even given me the scientific assessments against which they are they have come up with. So, my lord, because it's a principle of natural justice which has been violated, there was a batch of matters which has been filed, my lord, and similar orders was passed.
No, similar orders.
Only on the ground of principle of natural justice, my lord. We have come here only on the violation of principle of natural justice. Because neither any show cause notice nor any those documents have been.
Under which provision it has, this order has been passed? This
Well, the
communication
order
has been-
itself does not say any provision itself. Well, let me kindly see.
In your presence, it says.
No, Malad, that is, I have taken a specific.
Then it becomes question.
I've taken a specific stand, Malad. I've taken a specific stand.
Clear. It is clear that it was done in your presence.
Malad, may kindly see. Malad,
Yes, your representative.
Malad, I have taken that ground, Malad, specifically. Malad, what they are doing now, Malad, is, Malad, they are using satellite imaging. Now, Malad, all of our clients are absolutely not able to understand those. Malad, what they are doing is using the satellite, using the depth at which it is done, and they are calculating something. Now, Malad, when our original mining plan was given, it was not on the criteria of those satellite imaging. Now, Malad, this was, we have stated that categorically, Malad, that.
That must be addition to, in addition to what system they were having earlier.
No, Malad, that is the specific point, Malad. Malad, may kindly see para 30, Malad, page 13. I have categorically taken that stand, Malad.
It's very difficult then. Where is the provision under which this power has been exercised?
This penalty is provided in 51, but regarding demand.
Malad, that is.
Demand penalty is there is demand.
That must be conditions in your license. I think.
No, my lord, license, lease is also there, but my lord, as your lordship said, is under 51.
Because it must be, should be calculated on the basis of your transit passes. That quantity must be written.
Transit, I completely bought.
On the basis of that, they should have calculated. Probably they could not do that. That is why this drone thing.
My lord, as your lordship, I completely bought. That is how they do it. My lord, now here, that is our exact point. That you have suddenly come, you are saying is in front of us, we have said we are not there. Now, my lord, they are not producing any documents where our people have.
This would have arisen because we may have transported in the absence of transit passes.
No,
Yes,
if that be so, my lord, that would have been a specific query. But my lord, here every lease were granted that, my lord. Now, my lord, may see 51. If my lordship has the same book, my lord, then it's page 60.
Why don't you give us the provision?
My lord, rule 51(1), my lord.
That is the penalty.
Penalty, my lord.
No, examine, in fact, in these orders, there is no reference to any provision under the rules.
My lord, I completely bought on.
So we will have to examine.
About penalties, your lordship.
Penalty is different. That requires
No penalty, in fact, there is power of inspection under 57. And then.
Imprisonment and that is regarding.
Here in case it should have been the penalty only because a fixed MGQ is there, Lords. Beyond that, if they raise, Lords, then it will attract penalty.
Exactly, that is what we are discussing, that how did they get it? Nothing is written in order, they say
Yes,
it's wrong
it's
calculated.
satellite imaging, they said
The principles of natural justice is too general proposition. That can be applied, but that has to be applied in the context of the power which has been exercised. What is there? If the statute provides for any appeal and he wants to avoid that appeal only for the reason that he will have to deposit, pre-deposit condition is there for filing appeal. So these are circumstances which will have to be looked into.
My lord, here the entire, as it fell from your lordship, my lord, there has to be some basis under which this demand has been made. There has to be some basis. As your lordship knows, my lord, here, as it fell, my lord, there are mining plans. I have to, whether I am doing excess of mining plan, on what basis are you examining that I am doing excess of mining plan?
That is one of the questions.
My lord.
The main question is, which power they exercise
I completely buy.
while issuing the.
That is also not there, my lord, in this demand
It
notice.
may not be. The demand notice, it may not be there, but and on
Well,
that
as
ground
a-
only the.
As your lordship knows, my lord, this is minor minerals. These are not major minerals that leases are being taken up by big corporates. Well, these are minor minerals.
Then we see, even for grant of 5 rupees, we need to understand the law.
No, absolutely. I bow down. No, my lord, what I'm saying is my perspective of my client. My lord, they are small businessmen who are doing these query operations.
They cannot be small for the reason that the demand is 1,87,91,000. So,
My lord, that is precisely why they have
salary for-
completely lost. My lord, that
salary
is why
for-
they are extremely shocked.
salary of a High Court judge for 8-9 years.
You know, that is precisely why they are shocked, my lord, because that is why, my lord, all of these things were given, my lord, without any notice.
Just address us on the, please, all of you.
Yes,
Please examine and then address. As jointly requested. This matters on. Next Monday?
The lordship will be kind enough to stay the certificate proceeding.
Not now.
This is pending since 2022. No instructions as yet.
No instructions.
My lord, actually, in the meantime, what had happened was, well, my lord, I just wanted to bring to your notice. This was in 2022. In 2023, my lord, as per instruction, my lord, I'm stating, in 2023, what they did is they issued a show cause notice, which was not done here. They issued a show cause notice. Some people replied back saying that you are relying something on show cause notice, please give us the documents. They did not, they went ahead and gave a demand. Though in those cases, my lord, in those batch of cases, these orders were passed and with the state being there saying that please send it back, we will give them all the documents and rehear it. My lord, this has also not been done here. That is the entire.
We will see. We will see if we'll lay down.
Grateful. Monday.
Monday.
Two matters.
Well, both 20, 42 and 40. Grateful.
44.
My pleasure, Lordship. My lord, this is an application for WBC PIL challenging the order dated 25th November 2020, Your Lordship, passed by the Collector Sambalpur. In pursuance with the order dated 19th September 2022, passed by this Honorable Court, Your Lordship.
Which order you are challenging?
My lord, last occasion, as for the direction of this Honorable Court, I have filed the order in memo, Your Lordship. It has been attached.
How can you do that?
Can I pass it, my lord?
What is this about?
Actually,
My lord,
it has been granted in favor of BPCL, my lord. We are proposing to install a gas station to supply fuel, LPG gas to the adjoining locality. And the petitioner is challenging the grant of lease to me. This is the core issue, my lord.
Your Lordship, the collector has passed the order, but it was not the reasoned order. The fact being that I would like to go through Annexer 7, Your Lordship, page 42, Your Lordship.
Is this
Para 4. May I read the relevant part, Your Lordship?
Yes, how is this a PIL, madam?
My lord, it is for the well-being of the society at large, and the villagers are affected. They are concerned about the safety of our village, Your Lordship.
So according to you, what should be the plan?
Your Lordship, according to the gas cylinder rule 2016, Your Lordship, section 48, subsection 3B, Your Lordship. For storage of liquid filled petroleum gas in cylinder provided, no objection certificate shall be provided, Your Lordship. Now I would like to go to opposite party number 5's counter affidavit, Your Lordship. They have mentioned in para 12, Your Lordship, point number 12, Your Lordship, that they have the order has been passed in 19th February 2022, and lease has been granted, your lordship, for installation of mother station, your lordship. But again in para 16, your lordship, they have mentioned that they got the NOC on 18th August 2023, your lordship. That is quite later. Though the matter was sub judice and no stay order was there, they got it later.
But we are to take permission from the exclusive authority. After that only we can commission.
Yes, your
Till
lordship.
now we have not obtained. We are in the process of obtaining, my lord.
So without
No, your lordship, it was
you have not
said
yet
that-
obtained
No, my-
permission.
We have not
No,
started.
your lordship, on kindly come to the para point number 12 of counter affidavit of opposite party number 5, your
No,
lordship.
you were referring to some provision under the rules. Where is that?
And that is your lordship, gas cylinder rule 2016, section 48.
Gas cylinder rule.
Yes, your lordship.
Where is that? Yes.
Section 48, subsection 3,
You get that?
surplus B, your lordship.
Yes, 21.
Number of rules are there.
Gas cylinder rules.
Can I pass it on, my lord?
Just a minute.
Surplus 3, surplus B, your lordship.
This will come subsequently. First you will have
madam.
the plant
Yes, madam.
and thereafter storage of cylinder.
Yes, madam.
So as regards the plant, that itself is offensive.
Till now,
More
the
dangerous than storing
till now
cylinders.
the collector has not issued my NOC because of this pendency of this PIL. They are not issuing me, the district administration has to issue me the permission.
For what?
Then to start the operation, then it will go to exclusive authority.
So that they are objecting. So they don't want the collector to grant you no objection.
That their
Why-
prayer is the grant of lease, my lord.
Panchayat
Yes, ma'am.
has to follow, has to have a meeting, can't do it on.
They have
can't do
given
it
their
on
NOC,
own.
my lord.
Where?
No, your
Can't do
lordship.
it like that. They have a meeting.
Page 16 of my counter affidavit, page 56, para 16, my lord.
16 of your counter.
My lord, later they have added, but I don't have any instructions.
Please
That
wait,
is
madam.
Wait.
Yes, sir.
Just see.
Ms. Panda, please wait.
Yes.
He had filed an objection.
Yes, madam.
Then you said Tahsildar heard and passed order. What is the order? Duly heard and passed order. What is the order? Para 16 of your counter.
Then thereafter, they have granted permission, my lord.
Where?
NOC.
What? That you have not stated anything.
No, that is the counter by the state, I
Okay,
think.
state.
3 and 4.
Where is that?
So-
Next year, where is the order? What did the Tahsildar say? Sarpanch has, I was under the impression Sarpanch has agreed without taking consent of the villagers.
No, here,
But
no,
Sarpanch has given objection.
no, here, in fact, no lots, I mean, that
Grama Sabha or whatever.
Gram Sabha is not required.
But
Here only.
My
not
lord,
the lots,
Annexure
GLS
5 of my
alienation
petition, your lordship.
Please wait,
Annexure
madam.
5. Yes, sir.
We will not hear you, madam. Let's discuss after 4 weeks. This is not the way. Please learn.
Sorry, madam.
In the tendency of the present rate application shall not come in the way of authorities taking appropriate decision. Yes. Next, which item?
I don't know. 45.
At the outset, my lord, last occasion, want that PCN. It's a quite voluminous document. Today only I got it. I filed the extract of that bit document. But my lord, if you want to, I will get it a Xerox and file it, my lord. It's quite voluminous. Today morning only I will receive. The case is, my lord,
That is the tender document.
tender document.
This application is pending since 23. I mean, you did not have it earlier.
No, I have filed the extract. I have filed it. The relevant person I have filed, but because it is a voluminous one, I could not file it and it was not with me. Today morning he has given me, I filed it. That is
Yes,
my.
I am appearing for the opposite party number 5, my lords, the successful bidder. The
Yes.
impugned order is annexure 9, my lords. And the tender has been installed, my lords, is pending. It's a pipeline work, my lords. The agreement is executed with me. My labors are there, my lords. Since 1.5 years, this is pending, my lords, and this is the
I am
ninth.
not asking for in time. Let's place it. Only I have stated at the outset. Why are you so unjust?
Yes, please make your submission.
Here, my lord, kindly turn to page 17, annexure 1.
Let us see the interim order first.
Interim order.
Yes.
Interim order was, my lord, but that was not extended. So I have stated it is some miscommunication. From 1/3/23, it has not been extended. But the interim order was no final decision initially.
Interim order was 4/2/2023.
31.
Hmm?
31 is going to be extended on 30th January.
Inadvertently, it is.
No third party interest shall be created till 14/2.
Right. In not sell, my lord, my case is there was a tender. This petitioner has applied for.
So what problem do you have because of any interim order, Mr. Mohanty?
My lords, due to the interim order was there, my lords. Prior to the interim order was passed, the agreement was executed with me. My lords, I was the successful bidder. Now the government is not allowing me to work, even though the interim order is not extended, my lords. But they're not giving me.
Let me complete, my lord. Let me complete it.
Just a minute. Let us be clear on the interim thing. If there is no interim order, then why are you not doing it?
I will obtain instruction if there is no interim order.
Interim order had been extended till 1st March. Thereafter, no extension.
It was not extended, my lord.
List this matter. When do you want?
My lord,
tomorrow?
Even tomorrow, yes. We can.
List this matter tomorrow. We clarify that.
My lord, that will be prejudice, my lord. Only tomorrow, my lord.
That should prejudice. This is 2023 matter. There was one interim order. That was never extended.
No, it was extended.
Where is that?
There are 2 extensions is there, my lord. Kindly wait.
Where is that?
Yes. It was extended up to 1/3.
Just a minute.
My lord, kindly.
Where by which order?
First one you saw, February 2023.
And then therefore 14/2/2003 it is clear that interim order shall continue till 1/3/2023.
Yes, thereafter
1/3/2023 the matter was taken up,
my lord,
but it was not extended.
Yes.
So therefore we will have to clarify, because he is raising this stand that because of raising this point that because of pendency of the writ application he is not getting. So
but it was not vacated, nor he has filed any petition. If my lord will take up tomorrow, my lord,
no requirement.
I am ready, my lord.
We are just clarifying. It is clarified that as on date there is no interim order in operation. Full stop. Yes, tomorrow we can stay. Tomorrow we can pass an interim order. We don't know, depending on your submissions.
My lord. May my lord, it will be taken up at 2 p.m. my lord, so that I will.
Why? It can be taken up earlier.
Yes, ma'am. I am.
And if it is not taken up, then
only my humble prayer is, my lord, can be taken up tomorrow.
Yes, no. If it is not taken up, and if according to you the matter is urgent, we can take up in the second half.
My lord, that much, ma'am.
Madam, beg your pardon, madam. Item 47 may be taken up after vacation.
No, my lord. I'm for the appellants, my lord. And my humble prayer, my lords, have been pleased to direct the office to list the matter today. So it was actually matter was hard in part on. My lord, I humbly pray tomorrow, my lord.
Tomorrow it will.
Yes. Deeply.
Pardon.
Item 51. Item 51 may be taken up tomorrow or day after.
What is that?
There is a tender matter. I have submitted my.
All right, it will be there. Cases shall be there tomorrow.
Lordship, I am extremely pardon to mention. I mean, this is Lordship, son-in-law of the petitioner is in police custody since last.
Mr. Paikare, Mr. Paikare, your name is being shown as Mr. Paikare mentioned. Are you Mr. Paikare mentioned?
Yes, Lordship.
All right. Now, what do you want?
Son-in-law of the petitioner is in police custody since last 32 hours and has been brutally assaulted. And he has not given food. Right
What
now,
do you want?
Lordship, Lordship may direct him to direct the concerned police station to produce him before the
Have
magistrate.
you filed any criminal habeas corpus application?
Yes, Lordship. Yes, Lordship.
Make a mention before an appropriate bench.
Lordship, the bench is not available today. That's why I'm mentioning.
So make a mention tomorrow. What has happened? No, what is? When?
Bhubanesh, it's excise mobile unit Bhubaneswar excise police station, Bodagar.
When?
Yesterday morning, he was arrested.
And he has not been produced.
Yes, Lordship. Not yet produced.
All right. We may take up the matter. Just give the case number. What is the case number?
PWPCRL 29896.
29896 tomorrow, 10:30.
29896.
It's my diary number, not yet name.
It's diary number, Lordship.
It's diary
All right,
number.
diary
It's
number.
filed, but defects may not
Yes.
have been.
Yes. Please seek instructions. Please.
Lordship.
What is the case
But
number?
it says that excise matter, some excise matter. I don't know.
Police station, excise, that outpost has been detained.
No, there's no output. Excise authority might have detained him with some.
So
Yes,
please
yes.
give have you served a copy of the writ petition?
Yes, Lordship. In e-filing, I have filed this.
Served on the office of the advocate.
I will get the diary number so
Please
that I
find
can find
out.
out.
You please find out and then please inquire
Yes,
out.
please.
It's a serious matter if
Number 18.
he is correct. Huh?
Number 18.
Number. Give the number again.
Diary number.
29896.
29896.
Much